All right, everybody. Justice of Process is here. The show is started. So I was going to try to do something a little different. We're going to try to watch and react to a video I thought was okay to do, and apparently it shut my stream down. So we deleted that stream, and I decided, you know what, I'll go on and do what I should be doing anyways, and that is talking about the trial that we have that is in deliberations. So I thought I'm not going to do a long show tonight. I always say that, but really I'm not going to tonight. But I thought, you know what, I want to come on, share some thoughts, share where I think things are, and I thought, you know what, a cool thing to do tonight would be to watch the contrast between the state's final argument with Jennifer Crumbley and the state's final argument with James Crumbley. Contrasting the two, we're going to watch Jennifer first, and then we're going to turn around and watch James Crumbley. And we're going to talk about the contrast between those two arguments, because there is a huge contrast when you watch this and you see it for yourself, just what the difference is. Now, I think it speaks volumes to the difference between the two cases. Now, my thought is tomorrow, I think this jury could be out for a little bit. I think it's going to be a lengthy deliberation. I think that we might have a verdict tomorrow afternoon. It could drag into Friday, because I think the defense did a really, really, really good job in this case. And they did a heck of a job driving home the point. And Karen McDonald does not like the facts of her case this time. Now, she liked Jennifer Crumbley's because she had all sorts of character assassination, and she was able to drive home that Jennifer Crumbley was this horrible mom who was out there, interested in infidelity and swinging and everything else, while her son was allegedly home suffering. And the attorney in that case just kind of let the prosecutor run wild, because she came across woefully unprepared. Again, it was a unfortunate showing. Jennifer Crumbley ends up convicted of everything. Now, Muriel Lehman has presented a totally different case. She's presented the case I said should be presented, focused on the burden that the prosecution has. You can see Karen McDonald very uncomfortable, very concerned in her final argument, as you're going to see. And just a stark contrast between the two trials and what's going on. The issue that Karen McDonald knows she's really weak on, and that she does not want this jury to think about, is it's got to be reasonably foreseeable that Ethan Crumbley was planning a mass shooting. That, in other words, that James Crumbley has to believe that it was reasonable that he would have done this, and that he would have been thinking to himself, hey, my son's a danger. Now, there's no way to get around it, because she wants to say, well, it doesn't require you to know what James is thinking. Of course it does, because James has to be thinking, in order for it to be reasonably foreseeable to James, he has to be thinking my son is a mass shooter, which she knows is weak. She knows James didn't exhibit that, and she's trying to say and make some half-assed argument to say, well, because he raced home, called the police, and said, oh my God, that was my son, James at some level had to be thinking to himself, my son could be capable of doing this. That's not true at all. And that does not mean that it was reasonably foreseeable that he would have done this and did nothing. It does not mean that it rises to the level of gross negligence, because there's ordinary negligence and then there's gross negligence. The issue at hand is that James Crumbley did everything you would think a parent would do, given the circumstances that he believed. And it is his mindset. She doesn't want it to be that, but it is. She's asking, don't put the burden on me. Well, the burden is on you. You do have a burden, because the burden is, and the presumption is coming into the case is that we're going to presume that it wasn't reasonably foreseeable. You have to prove beyond a reasonable doubt that it was reasonably foreseeable. You have to overcome that burden. And as you're going to see, Karen McDonald does not like that. But you're going to see that it was handled totally different in the Jennifer Crumbley case. So let's get into that. Let's go into our Justice Cam room and start watching the Jennifer Crumbley closing or final argument. It's the final closing argument. It's not the first argument. This is the final words left to the jury, and we're going to contrast the two. So let's jump in there. All right, so here we are, guys. We've got it all queued up. So this is from day 7. This is the final statement that Karen McDonald, same prosecutor that's giving the final argument in the James Crumbley case. Let's listen to what she has to say to her jury, and I want you to notice the demeanor, the difference, the confidence that she has, because she's feeding off that jury, because that jury was pro-prosecution. I believe there is an absolute tell here and what she's looking at when she's looking at the James Crumbley jury. She's not connecting with that jury. She's not getting the warm and fuzzies back. And she doesn't have as good of a case. She doesn't have all the salacious details she had in Jennifer Crumbley case. And her case is looking kind of silly. And she's having to own that. So anyways, let's start watching here.
About the case beyond a reasonable doubt. That's not the law. That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt. Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to let's look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case.
Now, I want you to notice, what is she referencing there, right? I mean, she had a final argument that, Shannon Smith stood up there and just gives her cannon fodder, man. She comes out, it's like, this isn't about her. This isn't about her own life. This is about the evidence. This is about those kids. This is not about this arrogant defense attorney who wants to come in, and tell you, oh, I'm not a perfect defense attorney and Jennifer Crumbley's not a perfect parent, but it doesn't make us killers. And she is just standing up there slaying them, right? I mean, the demeanor, the difference you're going to see between how she was today versus how she is now. It's night and day. But let's keep watching.
I have to address a couple things, and I'm going to be quick. There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not in the evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter.
And see, that is an incorrect argument. Okay, that is not a correct. Now she can argue it, obviously, because closing arguments aren't evidence. But that's an incorrect statement. That's her trying to, it's almost as if she intentionally asked that question to that officer so that she could have this moment. I think that she, I almost think that's a setup, because they did it in this case or in James Crumbley's case, and she's trying to say, well, see, if we had foreknowledge, if we believed that they believed that there was going to be a shooting, they'd be charged with murder. Well, this is actually a problem. It is not a strength, right? It is not a strength, because for something to be reasonably foreseeable, you have to understand that you think that is a possibility, that they basically ignored the signs that their son was mentally ill. What does that mean? That means mentally ill, wanting to do a school shooting, and they bought a gun for him anyways. So how are we not how are we not at the next level here? How are the charges not different? You know, they want to argue that and say, well, that's not what it is. Well, then what is it? Oh, well, it's they don't know. But watch how she's going to push through on this. Much more confident. You can tell she's feeding off a jury because remember, she's looking right at those jurors. So she's getting that vibe right off of them. Let's keep watching.
And the elements, you'll get them. I read them to you. The standard, and what I have to prove is not that she knew that her son would go shoot up the school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things.
Okay. Again, she misstates what that means. When there was a need for ordinary care due to reasonable foreseeability, but she just skips right over and doesn't go, well, what is a reasonable foreseeability? A reasonable foreseeability is they have to have believed that their son was going to do this shooting, that he was mentally ill, they failed to get him mental help. What could they have done to stop this? Listen, she is skirting the legal opinion, and I will love to see how this survives on appeal, right? Because, see, the layperson watching this doesn't understand that there was an opinion that allowed this case to go forward. This case was only allowed to go forward and is only allowed to be viewed as an involuntary manslaughter case because of the fact that the reasonable foreseeability factor, that is the test that it has to pass first. Essentially, it means, again, you would almost have to prove the bigger charge. But they're basically saying no one's going to convict them of something intentional like that. So we're going to try to, again, blur the lines, so to speak, and try to skirt over exactly what this is and get the guilty verdict and say, well, we got the guilty verdict, appeals court. Are you going to let these parents with these 4 families staring you down? Are you going to let them off the hook? Are you going to reverse this thing? But the bottom line is the reasonable foreseeability. She can't escape that. What is reasonable foreseeability? Reasonable foreseeability is that they thought it was likely that this Ethan Crumbley was going to be a school shooter. Why would he be? Why was that? What was the duty of care? Duty of care is, well, we have a mentally ill person. Because see, the problem is, it's these double-sided things, right? It's like, okay, so you say, well, yeah, they should have secured the weapon. They should have done this, right? But the weapon was secured. So what should they have done? Well, she's basically saying they should have never bought the gun in the first place. Well, why shouldn't you have bought the gun in the first place? Because it's every person's right. This prosecutor doesn't like the Second Amendment. Every person's right to buy a gun. Well, the prosecutor gets to make that argument if she can say, well, these parents could have reasonably foresaw that their son was a danger and was going to use the weapon to kill other people. Okay? Normally, that intentional act by the son would negate any type of causal link to the activity because it wasn't an accident; it was an intentional crime. That they in intentional crimes are it's held by the courts. Intentional crimes of intent cannot be foreseen. So she's misusing the law here in a tremendous way, and of course, many legal commentators are letting her get away with it. But it's extremely disturbing the way Karen McDonald is using the law here, in my opinion, because she is skirting the lines of how this law should be used. Because you don't get to be able to charge involuntary manslaughter when the base act was an intentional act that negates and disconnects the manslaughter because there's no causal link. Now they're saying in this case there's a special cause. I have the case. This is probably a great time for us to get into it in a little bit, but the case that allowed them to proceed specifically states, and I think that's where a lot of legal commentators get involved in. They really don't understand. It's like, well, the case is allowed to proceed, and is it reasonably foreseeable, or should we have that? No, well, the problem is you don't get to say any of that. Yes, some of that makes sense, but that's not criminal because nobody's foreseeing that this person's going to pick up the gun and go do an intentional act like that. Now, if they are, then they're involved in the intentional act. It's conspiracy to commit murder. So the problem here is, and that's why the state is like making a double-sided argument. And it's, unless you really have an intrinsic understanding of what I'm saying, it may be hard to understand how egregious this is. But it's so egregious. She's doing it here. She's doing it here with a lot more gusto and a lot more confidence. Anyways, let's keep watching.
I apologize to the law enforcement in this room and any listening that I have to stand here and defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
I'm objecting because I'm allowed to argue based on what's in evidence, and Ms. McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
she's arguing. It's my
Yeah, and overall, you commented on statements of the police officers, you argued about the statements of the police officers, she missed to argue it.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the Sheriff's Office, Lieutenant Willis, Special Agent Brandon, the ATF, the Federal Marshals, the Detroit Police Department, anyone who the evidence checked, they were all in some sort of conspiracy. That's what you have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that, because I know that you're going to use your heart and your mind and your sense of reason, and you're going to look at the evidence. The first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden. Ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant.
Indicative, and I understand they're going to make. They tried to make this case that these guys didn't understand. They understood everything. What are you talking about? They understood everything except for the proximity to the event when the gun was bought, which is irrelevant. Okay, because again, it comes down to the foreseeability factor. But they knew everything. They knew he'd been at the gun range. That's what he told them. Remember, they spent an hour talking to him. They knew that that was the gun that he had used with his mom there. They knew that the bullets he looked up in class were, he said, was he had piqued his interest because of the gun range. They knew all about the they knew all about the grandmother. They knew, they knew his grades. They knew he'd made comments back in September that he hated his family. I don't even think the parents were aware of that. And these guys still said it was about sadness, and they did not believe that it was about him, wanting to do a mass shooting. So this whole argument that she makes where she says these school officials, their inaction doesn't matter. No, it greatly does matter because they're ordinary people. Remember, it's about taking an ordinary care and ordinary steps that they didn't even take. And the fact of the matter is Ethan Crumbley, remember also the fact that Ethan Crumbley was convincing and telling his dad, telling his mom, telling them, I want to go back to class. So that was also another factor that they were all taking into account. And it doesn't make any sense that you would think Jennifer Crumbley just says, well, who cares? Who cares? My son is about to come into school shooting and I don't give a crap. I'm just going to go on. It makes no sense. It makes absolutely no sense. Anyways, let's continue watching.
He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing. Her testimony is evidence. Jennifer Crumbley's testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged, sitting here, When Mr. Keys asked her about, where's his phone? You said you took the phone. You heard what she said. We took his gun away. We took his gun away. I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one, it looms large.
See, it doesn't, it looms large. Remember, this is the part she leaves out. She says it looms large. She didn't do these small steps, but the small steps only matter if she believed it was reasonably foreseeable that her son would commit a mass shooting. So the problem is she hasn't walked through that door. She wants to ignore that door. She wants to act like she can just jump over it and get to the other side. And of course, Shannon Smith just absolutely did not deliver where she needed to make it clear to that jury what they were doing. And you could see this trial was allowed to get into so many other places where there's accusations of police misconduct. What the hell are you talking about? That's not what this is about. This case needs to be very simple, like Miriam Lehman has made it. It's about the burden of the state to meet the proof of proving that it was reasonably foreseeable that Ethan Crumbley would have done this, and that both of these parents, or at least either of the parents that's on trial, would have believed that he was capable of doing that and done that, and then ignored it. And she's kept it right in sight. There are some things I wish she would have done different, but that could have strengthened it. But she is on track. That's why I believe you're going to see today, when you contrast this person right here, she's confident, she's going off, she's talking about all these different points, she's talking about Jennifer Crumbley's testimony, she's tearing her apart about her statements. That's why it was so smart not to put James Crumbley on. Ian. So let me address these two comments here for you. For one, what are your thoughts on them wanting to break early? Maybe they made a decision and went to sleep on it. I don't think so. I think that maybe they were tired. Maybe they did. Maybe that's what it is. It could be that quick. It's possible, but I think it also could have been just, it's been a long day, and they probably may have been hungry. They may have just been like, you know what? Let's break early. Let's get back into the courtroom tomorrow and just get a whole fresh day at it. But, it could be that we're going to walk in and it'll be all but the jury forms to be filled out. I think if it's quick, based on, as you're going to see right here, I think we're headed to a not guilty verdict. And, I see a path to quickness on both sides here. Obviously, we saw the quick verdict path in Jennifer Crumbley. Now, you said, I think they will find it. Well, again, it matters on whether or not they believed it was reasonably foreseeable. And maybe these guys do. Maybe they do. Maybe they do. Oh, they put their dinner. Are you talking about for tomorrow? They put their dinner orders in. I didn't catch that part. So you're saying for tomorrow, or are you saying they actually put their dinner orders in for tonight and then decided no need, we're going home early? Is that what you're saying? So you're saying that they actually put their dinner orders in for this evening, or this past evening, appeared to be digging in like they were going to go, and I missed that part. For tomorrow. Okay. Well, then I don't think. Yeah, I think it's just. Be honest with you, I think it's just. I think it's just. They were tired. It was close to 5:00, and they probably wanted to get home and thought, you know what, let's get going, because what it probably is, I think it could also be this. They get in that room and they realize they're 6-6 split, not guilty. So they realize it ain't going to be a quick verdict. Let's go home. Let's sleep on it. Let's come back in, and then let's talk, and let's get down to work on trying to figure out where we're going to go with this. And I think they may have realized how divided they really are, and they probably figured, let's attack this with a clear mind and a rested mind. All right, so let's finish watching the end of her argument here.
Larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago, she said, I wouldn't change a thing.
And this is why Jennifer shouldn't have testified. I mean, you see what
Of this case,
she's
and what Jennifer Crumbley did, and what she didn't do.
very confident in this. And I think that jury is feeding off of her.
Who are dealing with unspeakable darkness and grief. If only I could make that better, I could appease them, as the defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Muir. These are the parents of Justin Schilling. And not just their parents, they are mothers and their fathers and their sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty. 4 counts of involuntary manslaughter beyond a reasonable doubt. And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone for Molly Darnell.
Playing the emotional card, but really what I want you to watch is how passionate she is. She's on a roll. And I want you to contrast that with what we're going to watch when we watch today's final argument.
Lieutenant Tim Willis, who answered the call to lead, and maybe the biggest ask of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are not called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took, to be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day? You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate. And it could have saved Justin. And she sat here and she said she wouldn't do one thing different. And lastly, I'm going to
She gave them these moments
and a lot of people listening.
because she testified.
I know they're all asking, and they want to say, when she took the stand and she testified about her own loss, and she was asked the question, "You lost everything?" She said, "Yes." She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Thank you.
Excuse me. I hope you caught, okay, what she's saying there. She's basically saying, I mean, the way she kind of played with the words there, she said, she hasn't lost everything. Her son is still alive. Find her guilty of essentially tying in the fact this lady hasn't been punished because her son's still living. The killer didn't kill himself. The killer didn't unalive himself. The shooter didn't unalive himself. He's still walking around. So instead, she, otherwise we might be able to be satisfied to say she feels the pain because she lost her son that day too. But she didn't lose him. He's still there. She can still talk to him. She can still communicate with him. She still has the option to have a relationship with him. So instead, you know what? Convict her of involuntary manslaughter. And then, of course, like I said, she skips right on by and says it's ordinary care. It's the little things. But these little things do not rise to the level of negligence unless you have the reasonable foreseeability factor. And that's the part she just runs right around. Now, in this case, with James Crumbley, she hasn't been able to run around it. And James Crumbley makes such a good, compelling case that he was being a good parent. Anyways, let's watch and contrast Karen McDonald with James Crumbley, making that argument, and what a difference it is.
You know what my least favorite part of the trial is? It isn't listening to the defense argue
Look at her.
that her client is not guilty.
I want you to look at
She
her.
has a right to do that. It isn't even listening to what I believe, and I'm going to.
She's not connecting with the jury. That jury's not giving it back to her.
My least favorite part of the trial is that even when we're standing here and our criminal justice system
Watch how flustered she gets.
provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. Doesn't take it away. So, don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence.
And if you do that, you're going to find them not guilty.
I embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution.
But they are not looking back at her. I
Every single
guarantee
day,
you they are not
every year,
looking at her
for decades and decades and decades.
in a favorable
and
light.
decades.
And it's,
That's
of
the
course,
burden
she's
we
having to
have.
speak in front of them.
And it is not, despite what the argument is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the
Like,
way.
oh,
I assume he does.
what is this
We all
argument?
love our kids.
Suggested he doesn't love his kid? Are you kidding me?
So I embrace my burden, but I'm not going to embrace something that's just not true.
She doesn't even know what she's
It
saying.
is not true.
And she's trying to confuse them on what reasonable
that I
doubt
have
is.
to prove, and the people of the state of Michigan have to prove what James Crumbley knew. It is not true that the people of the state of Michigan have to prove. that
Yes,
he
it is.
that he knew his son was going to kill somebody.
What?
We've talked about
Yes, you
this
do.
before. If that were the case,
And I'll
he
show
charged
you
with
the
murder.
appeal. We're going to go through the case.
That's not my burden.
And I'll show you that
is
what she
not
said is
what
not
I
true.
have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the
A reasonable
elements
burden?
that I
What?
have to prove. Only the elements. Beyond a reasonable doubt.
She doesn't even know what the hell
common
she's
sense and your
saying.
reason.
She is.
The elements, and what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew.
You're
what
not?
he
Yeah, you
actually
are.
knew. That's not the law, ladies and gentlemen.
What he
That is
actually
not
knew.
The law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care.
Right.
That's what I have to prove.
And that ordinary care only kicks in when you have to say that it was reasonably foreseeable that he would have that they thought their
There's a
son
couple
would have done
things
this
I have to
crime.
correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence.
And neither are the
That is exactly
prosecutor's
what's
questions. What is the point of this?
But Special
She's-
Agent Brandon did not testify that it was safe. He would call that secure if an unloaded
Look at
gun
this.
was stored separately. In fact, that's not what he testified.
Yes, it
What
is.
he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony.
Yes, you did.
You did not hear that James Crumbley.
She does because she knows her
was
words.
Because he was trying to check on his son, and he
Look.
was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked.
See, they don't like the way she redefined the 911 call. And that's what she's
Defense
upset
counsel
about
put
because
up a
she knows how
statement
weak
from
the
the
case is. Look at this. This shook her.
About
This shook the
9/11
foundation of her
before my
case.
Dad hit it.
Yeah.
And she's urging you to find that credible. But
You should.
if you do, and we argue you should find it's all credible.
Right.
You don't get to pick one statement from a journal and say He was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth.
No, that was 7 months ago.
You have to use common sense. And I'm not going to go through every single thing that
Now, let's be clear on this, okay? And I want to be clear and walk you through exactly what the mistake here that the defense made, because I think the defense should have told a different story. But let's talk about what the evidence actually shows, okay? Because what the evidence actually shows is that in April of 2021, the family has a tremendous loss. James Crumbley loses his mother. Ethan Crumbley's upset about this. During that time is when these text messages emanate. Now, we all know that Jennifer Crumbley was not the greatest, not the greatest doting mother that she could be. She was consumed with other things. So during this time, of course, she's getting frustrated with Ethan, and Ethan's acting out, and Ethan is essentially showing problems. Now, they don't, or showing signs that he's troubled, right? But what's he troubled about? He's troubled about losing his grandmother. No, what he doesn't tell them is I'm thinking of violent acts. I'm thinking of killing somebody. I'm thinking of doing something violent. No, right? So it's interesting about the timing of when these guns get brought into the picture, right? When do we see the first guns purchased by James Crumbley? It is June of 2021, because what happens? We know that in April and in May, there are problems. Ethan is acting out. So what is the reaction of James Crumbley to that? What we know is he begins hanging out with his son, and they begin going to the gun range, and they make their first purchase of weapons. Now, you might say, in hindsight, that was terrible. That was terrible. But in looking at what they were doing in the community they live in, that is a hobby. He's going to start spending more time with his son. He wants to try to make a positive impact with his son. Clearly, they offer him and got him to say, hey, start writing in a journal. Start talk to me more, talk to your mother more. Of course, these are things that are said at the school. But the point is, the gun hobby begins, I believe, because this is James Crumbley believing, all right, I want to spend more time with Ethan. I know he's troubled and I care about him. And then, of course, they've enacted different disciplinary things to try to help him get better grades, like take away his video games or limit his video games and limit his cell phone activity and limit when he can talk to his best friend or hang out with his best friend. But the point is, the guns and the purchase of the guns come out of him caring. Now, this prosecutor would have you believe, no, it's him being a negligent parent. No, because that's not how he was thinking. And what he knows and what he thinks is absolutely relevant. Because what he thought was, let me help my kid. Let me spend more time with my kid. And I have an interest in firearms. He has an interest in firearms. As I've talked to relatives, I have several relatives, especially being from West Virginia and in around these areas, where there is a lot of firearm activity going on around me. And what I'm told is it is a place people go to relieve stress. There's nothing, for some people, more exhilarating or better than taking a firearm and a gun and shooting it out of range. And it's like, it releases stress, and father and son. And the father, again, his intention is to teach Ethan how to handle firearms and handle them responsibly. So what happens, right? They purchase firearms. They start hanging out. What do we see? No more text messages. Never again is another text message shared about Ethan believing there's a poltergeist or having problems or anything. Now, there are messages between him and his friend, but guess what? That said friend didn't believe Ethan enough to take it to his parent and say, hey, I think Ethan's really troubled. He's not getting help from his parents. Ethan is with school officials for an hour the day this goes down. He doesn't say, hey, my parents aren't willing to give me, or not willing to support me. They don't love me. I want counseling. I've asked them for help. Listen, he could reach right out to them, and they would have, at that school, they would have had him with all the help he needed, right? But he didn't do that, because what happens is Ethan isn't obviously your normal kid, right? He's thinking, as he gets more interested than he goes, he is disturbed in a sense, I guess. But he's not showing it, because what he's doing is he's tricking his dad. What does he say? What can we infer from the journal entries? We can also infer that he says, I had to convince my dad to buy me the 9mm. There were financial concerns. His dad was kind of like, we just got, what do you need? We got the Keltec. We've got the Derringer. What more do we need? This is supposed to be fun. He convinces him. Well, I can assure you he's not convincing him by saying, Dad, buy me this 9mm so I can go shoot up a school. What does that tell you? That tells you that he is exhibiting behavior. He is convincing his parents. He's making them believe that he wants to learn about guns, that he has an interest in guns, that it's a hobby. So much so that what do we see happen? When his friend moves away and the parents are now trying to spend more time with him, because, again, they understand he's had a tough year. He's had tough adjustments from being at home. What do? They're not ignoring him. Jennifer Crumbley isn't ignoring him. She didn't take him to the damn gun range, and they said it themselves to go teach him how to shoot up a school. No, so then why'd you take him to the gun range? Oh, because she is an uncaring parent who doesn't have anything. Because she didn't even care about guns. She went to the gun range because she loved her son. She went to the gun range to spend time with her son because it was being looked at as a hobby. They thought they were doing something positive for him. They had no reason to believe that he was ever going to go do an intentional act of picking up a gun and committing a mass shooting. As a result, none of the actions or activities that they're saying would require ordinary care are irrelevant or rise to the level of gross negligence. So what happens? They're pushing into the school. They arrive at the school, and what does Ethan do? He writes this. They get a call from the school about the bullets, right? To which the school doesn't even make a big deal about it. They don't even ask for a follow-up call on it, right? And then this paper comes in. So what do? Who normally goes to the school? Well, we know from the Jennifer Crumbley trial that would be James Crumbley. In fact, Jennifer expected James to go to the school because she was at her job and he was doing DoorDash, which does add the flexibility of him being able to go down to the school for something like that. But due to the fact that they don't get in touch with each other, she ends up going down to the school anyways. They arrive at the same time. They walk into the school, and what happens? Who jumps on it? James sits there. James actually questions him about that worksheet, right? Telling you more about what they're thinking. He's thinking to himself, oh my God, he wants to kill himself. That's what he's being told by these school officials, right? So they're having this meeting. And what does Ethan do? Ethan has one goal. He wants to get back to class. So what does he do? He does exactly what he did to get the gun. He does exactly what he's been doing for the last few months. He turns on the charm, and it's the exact reason why he's sitting behind bars with a life with no parole sentence, because he turns on the devious side. And he goes in and he convinces them that he wants to go back to class. He doesn't want to go home. The thing that the prosecutors aren't talking about is there is a kid in that room who's not a kid. He's not 3 years old. He's not 8 years old. He's a devious 14, 15-year-old boy who has a motivation to commit an intentional act inside that school. One that her office has found him guilty of. One that her office has asked for life without possibility of parole. So she knows that person is in that room, and he is controlling the room because he's got counselors who are trying to do the right things for him. He's got parents that are trying to figure out the right thing to do for him, and he's telling them what I need is to go back to class. So much so that he's requested a science book to make sure he stayed in school that day. Now, we don't talk about the fact that Mr. Ejak had the very book bag with the very gun in his hand and did nothing. Where was his failure to take ordinary care? Couldn't he have just pulled that out of the book bag? Couldn't he have just looked in the book bag? Couldn't he have said, hey, let's check the book bag? Didn't you say you were at a gun range this past weekend? Mr. and Mrs. Carmen, do you have any reason to believe? He didn't do any of that, right? So where's his charges? Well, they're not there because, see, he doesn't have a kid. It wasn't his DNA that was in that school shooting people up. And it wasn't him who decided to be the gun owner. This prosecutor's a problem with gun owners, clearly, in my opinion. I mean, that's what I see here, at least. And you see that in the inference at the end of the Jennifer Crumbley case, where she says, it's in front of argument, they bought him the gun, convict him of manslaughter. That's it. That's the crux of her. But anyways, we're at in the conversation. So they're there, and at the end of the conversation, and this is the one question I wish the defense attorney would have asked. It said, listen, as counselor, I can't remember the counselor's name, but Mr. Counselor, isn't it true that you have a duty to make sure that you get the best outcome for the student? Yes, I do. Yes, sir, I do. Correct? And that day when you left, you believe you had the best outcome for Ethan Crumbley, correct? Based on the circumstances and facts that are in front of you at the time. The conversation, everything, correct? Yes. And those things were correct. You knew that he had and just to summarize, you understood that he had lost his grandmother. You understood he'd had trouble with virtual school. You understood that he lost his best friends. Oh, Sean Hopkins, thank you. Mr. Hopkins, you understand that he had problems with his friends. You understood that he'd been to the gun range. You understood that he drew on that paperwork. You understood that you'd seen that he was writing that he wishes his family never existed. With all of those facts, you believed that the best outcome for Ethan Crumbley at that moment in time was to return to class and be with his friends because you thought he was depressed and was wanting to unalive himself. Isn't that correct? And you'd have to say yes. And isn't it true the only thing you didn't know was that gun that they took to the gun range was bought 4 days ago, correct? Or 4 days prior to the shooting. That is the only thing you didn't know, correct? And again, the jury would have to assess the impact of what that would have made to him, which really is none, because he knew he had access to firearms because they were at a damn shooting range. He's looking at bullets, and he tells them, why am I looking at bullets? Because I was at a shooting range with my mom, and I saw this type of ammo there at the shooting range. So these guys already knew it, and they let him back in. And they decided the best outcome for Ethan Crumbley at that moment, and that is the standard. Sean Hopkins' standard is best outcome for the student. Mr. Ejak, the best outcome for the student, you agreed, was not to discipline him, not to suspend him from school, but the best outcome for Ethan Crumbley in your eyes at that moment with all those facts that you were aware of. Boom. And then that was a moment she could have taken then in front of the jury and said, both of these guys. And she, as in Miss McDonald, couldn't have got away from that because Miss McDonald wants to run away from that because she knows James Crumbley is not the type of person that she had in Jennifer Crumbley, where she could argue the inappropriate things she said while testifying. She could argue the inappropriate things she did on her husband. She could argue the inappropriate activity she was doing during the time she was supposed to be at a school meeting, during the way that she was, the one that was always away from the house, always doing something else, always distracted and never really giving Ethan any time. Whereas James Crumbley gave Ethan all his time. They hung out. He established the hobby of going to the shooting range. He was the one that took him to school every morning. He was the one to talk with him. He had a conversation the morning of and said, all we want is what's best for you and to get good grades. How does that align with a man who believed it was foreseeable at that moment, or that you would believe that in his mind it was foreseeable with the given facts and circumstances that he would have had to recognize in order for him to be negligent and said, I'm just going to ignore my duty to care for my son, to care for people that my son can injure, and just say, screw it, I'm going to let him go back to class because I don't care what happens to him. And that does require that. That is what is required in reasonable foreseeable, for something to be reasonably foreseeable. She can't get away with that. Anyways, let's keep watching this absolute train wreck of a final argument.
That Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. He gets called to the school, and the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image is there and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense. Because any reasonable person, which is the standard you have to use, using ordinary care, would know that. Because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun.
The cable lock
And whether
is.
that lock was used or another lock.
There
was
isn't a
used.
requirement
But
for him to
you
do
know
anything with that
that
cable lock.
Whoever purchased that gun had to be 21 years old.
What the hell does that have to do with anything? I mean, it's
We've been telling you since this case started, it would take tragically small things to make this, to prevent these deaths. And you're hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around. My dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord.
and this is the dramatic
the cable lock.
way she's going to end this with
We
her
know
putting the
that
cable lock on.
was in the home. We know it was.
But none of this matters that it was in the home or wasn't used unless it was reasonably foreseeable,
This is me.
which it
inserting the
wasn't
cable lock.
based on. I mean, that's all nice and well, but it's not required by law that he do that. And that's me earlier, getting upset.
Takes less than 10
Desperation.
seconds.
I smell desperation by the state. She knows she's in trouble.
Don't
She
have to
knows
go
her
find
case
it.
is in
You
trouble.
don't have to go buy it. It was
I
provided.
agree,
It's
Steve,
right
from
there.
earlier. She's
Just
watching that
watch
jury,
it.
and I think she knows she's lost them.
10 seconds of the easiest, simplest thing. One of which, by the way, not the only.
Because remember,
way.
she's the head
Locking was
prosecutor
not the only way to prevent this, but it was one way.
of the
and it
county,
took less
so
than
she
10
knows
seconds.
she is in trouble. Flustered, not looking good at all. Doesn't have all the salacious details that they got to put in with Jennifer. Doesn't get to say, oh, she said one thing. She was asked, is there anything you would do different? And she said no.
Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These are the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew. The guns were kept in the bedroom. This is where he says he hid the gun. The armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use.
Except for the fact that you have to have the foreseeability factor. Exactly what I'm thinking to
Where's that
myself. I knew I'm
We
coming in with
know
that. Because it wasn't
that
foreseeable.
James
Thank you,
Crumbley
Steve.
went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability.
No, it's not.
That's a person who suspects their own son.
Yeah, after the fact.
And that is what I have to prove. Foreseeability.
That
to
is
an
not
ordinary-
foreseeability.
A reasonable person using ordinary care. This case is not a statement about guns.
Yes, it
It's
is.
not a statement about parental responsibility.
Yes, it is.
It's not about kids doing kids things.
Yes, it is.
The kids
Well,
on
no,
November
it's not. I
30th
agree with that.
in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job, and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave
I
something.
mean, what is her point in this?
They don't come with a set of instructions. I'm not here to tell you.
She's trying to bond with the jury, but I don't, like I said, my read is she's missing the mark here in a big way.
But we do have a guide.
That's exactly what
We
your
have a
case is. It's
basic
ridiculous.
Standard for ordinary.
Thank you,
care.
Steve. I appreciate the input.
We all have
There is no,
doubts about
what
our
are you,
kids.
oh.
We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies.
What is rare about
It's
it?
the law. And it requires us to use.
As you can see, I got very fired up earlier.
And there is a consequence if we don't. In a very limited way that the law allows a parent to be charged.
Annoying me as well, Ian. Absolutely.
Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is.
Then they're going to find him not guilty then,
Listen to all
because
the evidence,
that's what the law would
and at the
require,
end,
or the lack of
you will
evidence.
prove that James Crumbley failed. He might love his kid, I hope he does.
Of course he
Stick to
does.
what I have to prove.
Oh,
Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate.
but he failed in
I
that
don't
by,
say their names to evoke sympathy.
yes, you do.
I say their names
You absolutely
because
do.
they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day. Because if James Crumbley had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble.
What? You mean what about
Kids
the,
wouldn't have
oh my
been
God, dude, this is
shot
crazy. She is
and
nuts. She
killed
doesn't even have an
in
argument.
that school on that day.
She's trying to make a passionate argument and she
I've got
can't.
my burden. Mr. Keystone, the people of the state of Michigan have met the burden.
No, they
to
haven't.
find James Crumbley guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor. I'm now going to read jury instructions to you. Does anybody need a break before I do that?
Okay, so obviously, Huge difference there, in my opinion, between the two closings. You have one that was fiery and passionate, one that was just all over the place. She was clearly befuddled. She was clearly not on her game. She was clearly not confident like she had been when she was prosecuting Jennifer Crumbley. Why? Because it's a totally different case. It's a totally different place that she finds herself in. All right, let's switch rooms here. Give me one moment. All right, so let's go. It's time to go. The final thing we're going to do tonight, and then we're kind of opening it up to for some final thoughts, and then we'll call it. But I wanted to I figured why not do this and talk about the case that's before the jury. So let's read. This is the opinion. All right, by the Michigan State or state of Michigan. So let's read this. We're going to read the opinion. And once you read this opinion and you see this opinion and you understand this opinion, it will change your understanding of things. And you will understand this is the law, because essentially this is what, well, it describes all the issues and why this went before them. But this describes exactly what the state needs to find, and contrast that with how Karen McDonald told the jury it was supposed to go. So anyways, here we go. Let's get into this. It's 17 pages long. We're going to try to read it as fast as we can, but it's important we read it from beginning to end, because I want you to contrast also the evidence that we just heard. 2 trials, 15 days worth of evidence, and I want you to see this is what they put forth in their probable cause hearing. How does it match up with the evidence presented at trial? You're going to see some differences there. Defendants James and Jennifer Crumbley are the parents of Ethan Crumbley, who shot and killed 4 fellow students and injured many others at Oxford High School on November 30th, 2021. Ethan Crumbley pled guilty to 4 charges of first-degree murder. In these proceedings, the state has charged defendants with 4 counts of involuntary manslaughter related to those same deaths. At the conclusion of the preliminary examination, the district court concluded that there was sufficient evidence presented against the defendants on these charges, including sufficient evidence of causation, and bound them over for trial. In a written opinion, the circuit court subsequently agreed and denied the defendant's motions to quash the charges, or otherwise dismiss the charges. The court denied the defendant's applications for leave to appeal that decision, but the Supreme Court remanded the case back to us to consider whether there was sufficient evidence of causation to bind the defendants over for trial on the charges of involuntary manslaughter. In other words, causation is the important factor, because the issue at hand is in involuntary manslaughter cases, if there's an intentional act involved that enters into the picture, the causation needed for an involuntary manslaughter charge goes away, because you can't have involuntary manslaughter when it's that is a result of a voluntary intentional act, such as choosing to do this. It's involuntary manslaughter plays on something that it's foreseeable that it could that the actions or activities could be deadly. Again, this would be along the lines of not securing a gun, leaving the gun out on the patio, and a young child picks it up, pulls the trigger, and kills somebody. That is an unintentional act. The child pulls it up, drops it, it goes off and shoots somebody, and they die. That was an accident, but you should have foresaw that leaving that gun on that table out unsecured, fully loaded with the safety off, that is a foreseeable outcome that somebody could pick that up, and if that gun were to be dropped, it could go off. That's why you'd have the safety engaged. That's the type of situation that the involuntary manslaughter law is made, not for this wackadoo way the state had to apply it here in order to charge the Crumbleys. That's why this was so novel. So anyways, here we're going to get into the background evidence now of what led to the charges here. You're right on that. I was actually thinking about that, Ian, that this has been a pretty big year for trials so far. A preliminary exam evidence. Defendants, a married couple, lived together in Oxford with Ethan Crumbley, who was 15 years old at the time of the unalivings. Jennifer worked full-time in the marketing department of a real estate company, while James worked for DoorDash, a food delivery company. Although it is unclear from the record exactly when evidence of his problems first arose, the record is clear that by early 2021, Ethan Crumbley began verbalizing situations he was experiencing that reflected instability in his mental health. Now, I want you to understand why I've made such a big deal about the way this case has to be perceived and thought about, because it is the instability of his mental health, right? Which at this particular point, when this was decided, his sentence had not been determined. Okay. So the instability of his mental health is a big factor here. But the state turns around and argues that no, he wasn't mentally unstable. What he was a devious criminal who was worse than any other school shooter in the history of the United States. And as a result, he deserved a life sentence with no parole. Yet they're going to, again, for purposes of making this case work, they have to come back and say, no, he had instability. They can't even say when it originated, okay? Because they just literally cherry-picked a handful of messages that you're going to see here, and as we saw in the trial, and said, this was happening. Again, surrounding the death of his grandmother. It wasn't that he had mental health problems. It was that he had lost someone that was close to him, and he was reacting poorly. Now, obviously, he had some issues going on in regards to wanting to do a school shooting. But the point is, those were not surface level. None of that was detectable. And the only reason why any of the things that came out that he was talking about here came out was because he was really acting out and wanting attention because his grandmother had passed. That's what I believe, at least. But anyways, let's continue reading here. For example, in March of that year, Ethan Crumbley sent a series of text messages to Jennifer explaining his desire for Jennifer to come home, sending messages in close temporal proximity describing his self-described paranoia that someone was in the house with him. There's someone in the house, I think. Someone walked into the bathroom and flushed the toilet and left the light on. And I thought it was you, but when I came out, there was no one home. There's no one in the house, though. And dude, my door just slammed. About 10 minutes later, when Jennifer had not responded, Ethan Crumbley sent another 2 messages, stating, maybe it's just my paranoia, and asking, but when are you going to be home? Jennifer did not respond until the next morning. According to the defendant's cell phone records, neither defendant called Ethan Crumbley that night. About 1 week later, Ethan Crumbley sent additional text messages to Jennifer. Again, notice, this is 1 week later that we're dealing with here, this time reflecting his belief that a demon was in the house, that it was throwing objects inside the house, that he had taken a picture of it. Okay, the house is now haunted. Some weird shit just happens, and now I'm scared. I got some videos and a picture of the demon. It is throwing bowls. I'm not joking. It fucked up the kitchen, and I'm going to be an outsider for a while. When Jennifer did not respond quickly enough, Ethan wrote, can you at least text back? Jennifer did not text back at any time that day, and her cell phone contained photographs showing she was taking pictures of James and herself riding horses at the time the messages were sent. Now, see, some of these messages I don't believe fully made it into James Crumbley's trial because they were to Jennifer and not James, and they couldn't prove James was aware of these messages. Ethan was either insane or trying to get less time. Well, exactly right. I think there was a mixture of all that. Approximately 2 days later, Jennifer messaged James about how Ethan Crumbley was doing. And James responded that he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer was not surprised by Ethan Crumbley's state, telling James, well, Ethan Crumbley was really worked up and out of control, so I can see why. Jennifer sent another message. All I know is he needs to eat, go to work hard, and not complain, and he can get his stuff back. Now, what does that sound like? That sounds like they're dealing with normal teenage stuff where Ethan Crumbley's not following the rules. He's broken some sort of a rule. He's lost things, and he's not meeting grade requirements. Like I said, at this exact time, his grandmother has passed away. He seems to be acting out. James then relayed something Ethan Crumbley apparently said that morning. He said, let me ask you a question. Why am I in your guy's room? Laughing out loud. Jennifer responded, oh my God. And James said, I totally thought you were giving him Xanax last night. And Jennifer stated she gave Ethan Crumbley melatonin, a natural sleep aid. Remember, this is 7 months before anything happens. Ethan Crumbley continued to experience hallucination type events for just 2 days later. On March 20th, Ethan Crumbley sent Jennifer several text messages in quick succession. I cleaned until the clothes started flying off the shelf. This stuff only happens when I'm home alone, and I picked the clothes back up, though. Once again, Jennifer was at the barn when those messages were sent, and she did not respond. The issue, as Jennifer Crumbley explained, that this was an ongoing joke where they said their house, or they try to convince each other it was true. There's a poltergeist in the house. This is also why the state should be required to prove the context of these messages, given the fact that they did not continue past now. So how do you explain the gap in messages? The most prolific text message conversations were between Ethan Crumbley and his best friend, which they never proved his parents were ever aware of. Just after midnight on April 5th, 2021, Ethan Crumbley sent text messages to his friend telling him he was going to ask my parents to go to the doctor's tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And I only told them about the people I saw. Amongst other things, Ethan Crumbley told his friend that he had researched his symptoms and believed he was having a mental breakdown. True to his word, Ethan Crumbley informed his friend that he asked his parents for medical help, but that James refused the request, instead giving him some pills and telling him to suck it up. Jennifer, according to Ethan Crumbley, laughed at the request because she did not believe he had any mental health issues, but was instead using drugs. This made Ethan Crumbley feel like shit, such that he considered calling 911 so someone would take him to the hospital where he could get help. Ethan Crumbley decided not to do so. He said because defendants would be angry with him. This appears to be the exaggerated ramblings of a teenage kid trying to make things sound more dramatic, trying to make himself and his actions sound cooler than what they were. That's how I read this. But this, again, it doesn't continue. Communications between Ethan Crumbley and his friend were about more than just mental health issues and problems with defendants. While many of the messages contain normal teenage banter, others involve conversations about wanting guns and making plans to buy them. For instance, 3 months before the shooting, Ethan Crumbley sent his friend an 11-second video showing him loading a magazine into a .22 caliber Kel-Tec handgun registered to James. Ethan Crumbley's friend responded, "Nice," and then wrote, "Now pull the trigger. Just kidding, just kidding, just kidding." Ethan Crumbley responded that, "My dad left it out, so I thought, why not laugh out loud? I know, gun safety, so it's no problem." Ethan Crumbley then said, "Now it's time to shoot up the school. Just kidding, just kidding, just kidding." So again, James Crumbley was unaware that his son was saying these things. Okay, he never saw them. There's no evidence he ever saw them. So yes, obviously in that moment, James Crumbley, the gun was left out, probably because maybe they go onto the shooting range or whatever, but it's not in proximity to the shooting, right? Because, well, we end up seeing an entry for that where he says, "I have to find where my dad hid the gun." I mean, that's the smoking gun that shows that gun hand or securing the firearm is not an issue in this case, at least for James Crumbley. October 2021, 7 months after the first message and evidence on topic, Ethan Crumbley and his friend were still discussing Ethan Crumbley's belief that he was having a mental breakdown. Defendants' text conversations during the same time period show no indication that they considered finding some help for Ethan Crumbley. Near the end of October, Ethan Crumbley's conversations with his friend via text message stopped. Then the Crumbley family dog and one of Ethan Crumbley's grandparents died. Jennifer told Curie Pennock she believed Ethan Crumbley was having a hard time because he lost his only friend, his dog, and a grandparent, all in quick succession. According to Pennock, Jennifer did not speak about Ethan Crumbley often, but when she did, she described him as weird and said he had no friends. Amanda Holland, one of Jennifer's co-workers, testified that Jennifer described Ethan Crumbley as quiet and brought up concerns about him feeling lonely after his friend moved away. Jennifer did not speak to either of them about getting help for Ethan Crumbley. Now you see where there were some other witnesses, obviously, that we didn't see in James' case because they were talking about things Jennifer Crumbley said. They couldn't come in against James. Another reason why the case against James is so weak. I want to know how Ethan Crumbley got the gun. He was obviously digging through their bedroom. The bedroom looked messy because obviously Ethan was digging for the gun. Probably when his dad was in the shower. I mean, again, who knows what was going on in there in the morning. But I would say it was probably dad's in the shower, mom already left for work, and Ethan goes in and starts digging around the room. He maybe even went in there when they were sleeping. Ethan Crumbley also kept a journal. The journal referenced his friend, contained a drawing of a decapitated bird, depicted a demon, and discussed various issues in Ethan Crumbley's life. Every one of the 21 pages of written material had reference to plans to commit a school shooting. In one entry, for example, Ethan Crumbley wrote, "I will cause the biggest school shooting in Michigan history. I will kill everyone I effing see." Ethan Crumbley also described a specific plan, explaining the first victim had to be a pretty girl with a future so she could suffer like me. That same page contained a drawing of a girl being shot in the back of her head. Ethan Crumbley partially blamed defendants in the journal, writing, "I have fully mentally lost it after years of fighting with my dark side. My parents won't listen to me about help or a therapist, and I have zero help for my mental problems, and it's causing me to shoot up the effing school." On November 26th, James and Ethan Crumbley went to a gun shop because James wanted to purchase a 9mm Sig Sauer handgun. To make this purchase, James provided his identification, filled out and signed the required form, and waited for completion of the background check. The form James signed indicated that purchasing a gun for someone else was illegal. When the background check cleared, James purchased the Sig Sauer, which was given to him in a case containing a cable lock, a trigger lock, an ATF Youth Handgun Notice Act pamphlet, and an extra magazine of ammunition. Later that same day, Ethan Crumbley posted 2 photographs and a video on his Instagram account. Both photographs were of the Sig Sauer, and the video showed Ethan Crumbley holding the gun. In the background of the video, the gun case, ATF pamphlet, and unopened gun lock are visible. The caption on Ethan Crumbley's Instagram post stated, "Just got my new beauty today, Sig Sauer 9mm. Ask any question, and I will answer." The next day, Jennifer took Ethan Crumbley to a shooting range. Upon arrival, Jennifer purchased 30 minutes of range time, paper targets, and 2 boxes of 9mm ammunition. A surveillance video from the range showed Jennifer and Ethan Crumbley firing the case, or firing the gun. Ethan Crumbley went first, and he showed Jennifer how to load the gun and help her shoot it. Clearly, Jennifer had no experience with firearms. Afterwards, Ethan Crumbley took the gun apart, put it back inside the case, grabbed the used paper targets, took the leftover ammunition, and left with Jennifer. Later that day, Ethan Crumbley posted on his Instagram account a photograph of the target with bullet holes through it with a caption stating, "Took my new Sig out to the range today. Definitely need to get used to the new sights. Laugh out loud." Jennifer posted photographs of the paper target and the gun in its case on her own Instagram account, capturing her post with, "Mom and Sunday testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye." Clearly showing that the guns in their case, as I have told the story, James, trying to connect with his son, decides, let's do this hobby together. And they start going to gun ranges together. They buy the Kel-Tec, they buy the Derringer. By Ethan Crumbley's own admission in his journals, he convinces his dad, "Buy us a 9mm, buy me a 9mm. I want to use it. I want to find it." I mean, in the area that we're in, her son's interested in guns. So what's she going to do? And this was what Shannon Smith tried to make the case and say, "I would rather do anything but do this." But she kind of like ruined it with, I don't know. It just did not come across well. But the point was, she was trying to connect with her son. So when you're trying to connect with your kids, sometimes you do things and you participate with things that you don't like. Bottom line, that are not your cup of tea. They're not what you would normally do with your time, but you're doing it with your kid because it's your kid and you want to connect with your child. Okay. And that's the point. And that's what Jennifer Crumbley is doing here. And Jennifer Crumbley doesn't do that if she doesn't care for her kid, if she doesn't care about his future, if she's not thinking about what's going on. And if you believe that a parent that cares about that child's future is going to provide him with a handgun, is going to take no steps to secure that handgun, but because they believe it's foreseeable that he's in a state of mind that he would shoot up a school, and that she's going to do nothing about it, that is ridiculous. So this in and of itself, the trip to the gun range in and of itself, was evidence and reasonable doubt that should have been apparent to that jury, but it wasn't argued that way, or it was attempted to be argued that way, but it landed flat with that jury. Now, in the early morning hours of Monday, November 29th, Jennifer performed an internet search on treatment options for clinical depression. Later that morning, Ethan Crumbley was back at school. While in class, a teacher saw him looking at handgun ammunition on his cell phone. The teacher informed Mr. E. Jack, Dean of Students, who forwarded the message to Ethan Crumbley's school counselor, Sean Hopkins, and another school official. Hopkins and the official met with Ethan Crumbley that day and asked him about his cell phone activity. Ethan Crumbley explained he was looking at ammunition because shooting guns was a hobby, and he had just gone to the shooting range with Jennifer and wanted to look up different bullets. Although Ethan Crumbley was compliant, calm, and understanding during the meeting, and acknowledged researching ammunition was not a proper classroom activity, a school official attempted to contact Jennifer about the incident, leaving a voicemail explaining that guns may be a hobby and there's nothing wrong with that, but that it was improper classroom activity. The official did not request Jennifer to call back, and she did not do so. This was in Sean Hopkins' testimony. Listen, these two guys were aware just by this line right here. He'd gone to the shooting range with Jennifer. He was looking up different bullets based on that trip to the student range or to the gun range. So, please explain to me how we could say that these guys didn't have enough information in their mind. Remember, they're aware of the paper or the assignment that he wrote where he said he wishes his parents didn't exist. He's aware of the dead grandmother. He's aware of the issues that he had in regards to virtual learning. He's aware of the loss of the dog. He's aware of the loss of his best friend. All of these things are readily apparent and aware, and yet when they made the decision for the best course of action for that student, which is what they were required to do as part of their job, they believed it was for him to return to class, thereby showing that an ordinary person exhibiting ordinary care for others around them. Now, of course, the state tried to say, well, no, there were other facts that they didn't understand. Well, the only fact they didn't understand was that the gun was purchased 4 days ago. That made no difference. They still knew firearms were available. They still knew they were around. And in fact, Mr. Ejack has the bag. Anyways, after receiving the voicemail, Jennifer began a text message conversation with Ethan Crumbley that same morning. Now, remember, these did not go before this jury either, okay? Jennifer wrote, seriously, looking at bullets in school. Ethan Crumbley responded almost immediately and sent a string of messages in quick succession. What? Oh, yeah. I already went to the office for that. It was in the first hour. All I did was look up a certain caliber at the end of class because I was curious. It was on my phone, completely harmless. The teachers just have no privacy. I want you to look, and what should be taken from this is the deviousness, and it was used against him and argued as signs of the way he was able to manipulate people. That was argued for purposes of getting him a life sentence. Now here it's argued as, well, Jennifer is ignoring him. Jennifer's not taking this seriously. Jennifer is aware of these things. Well, but she's aware, but if you look at the manipulation of her son, jumping in and deciding, okay, I'm going to, I'm going to convince her that this was not a big deal. And what does he say? That's exactly what he does. He says, "Oh, it's no big deal. It's just the teachers. They don't respect my privacy." Again, knowing how Ethan Crumbley was skilled at knowing how to hit the pressure points of his parents and authority figures in his life to get them to bend to his will. They said, I'm all good. I understand why they talked to me. And they said that am good. And this is nothing I should get in trouble about. Jennifer wrote back telling Ethan Crumbley that he was not in trouble, that she just wanted to inform him to school after a voicemail, and then added, did you at least show them a pic of your new gun? I mean, again, this is not the messages of a parent who thinks, oh, yeah, he's going to shoot up a school, right? Ethan Crumbley followed up with another string of text messages to Jennifer. No, I didn't show them the pic. My God, I only told them I went to the range with you on Saturday. It was a harmless act. And I have this bullet cartridge in my room that I didn't know what kind of bullet it was. And it said it was a 22. So at the end of the first hour, I just looked up different types of 22 bullets. I guess the teachers can't get their eyes off my screen. Jennifer responded by writing, laugh out loud. I'm not mad. You have to learn to not get caught. Ethan Crumbley texted, I know, laugh out loud with laughing emojis. Asked to listen to the voicemail and explained that he was not trying to hide his cell phone, but did not know a teacher was looking. Jennifer told Ethan Crumbley she saved the voicemail and then spoke briefly to a coworker about the voicemail. According to the coworker, Jennifer did not seem concerned about the message. None of this, to me, is anything of a. If it's anything, it demonstrates how manipulative Ethan Crumbley was, and it also demonstrates that the state of mind of Jennifer was not that she was thinking she was dealing with a kid that was going to go shoot up a school. She was dealing with a kid who she thought was just interested in what bullets, interested in guns, and had a healthy interest in this. And she was trying to be a cool parent, trying to give him a little leeway and trying to work with him. Again, there's nothing criminal about what she's doing. On the morning of November 30th, Jennifer went to work. James went to the barn to check on a sick horse, and Ethan Crumbley went to school. In Ethan's backpack was the Sig Sauer handgun in his journal. While in English class, Ethan was caught watching a shooting video on his cell phone with the teacher, which the teacher reported to EJAC. So EJAC knows again more interaction with guns, yet no search of the book bag. EJAC forwarded the message to Hopkins at 8:30. And then it says here, there's a number 7. We'll read this. The last entry in Ethan Crumbley's journal was written the day before, where he noted that he had the gun and ammunition, specifically mentioning the 9mm Sig Sauer, and proclaimed the school shooting would be the next day. Ethan also wrote, "Forgive me," in big bold letters. By the time Hopkins saw the email at 8:50 a.m., Ethan Crumbley had switched to math class. At about the same time, another message was delivered to EJAC from Ethan Crumbley's math teacher, who had photographed Ethan Crumbley's handwriting and drawings on a math worksheet and attached it to the message. And this is the famous sheet. So this is what you're thinking. The thoughts won't stop. Help me. It looks to me, I can see where. It looks like he shot himself in the head. It looks like he's got his hand up in that way. Blood everywhere. And of course, it's disturbing. So what did they do? They talked to him. After EJAC went to Hopkins' office to discuss the math worksheet, Hopkins went to Ethan Crumbley's classroom, grabbed the worksheet, which Ethan Crumbley had already attempted to modify, off the desk, and walked Ethan Crumbley to the office. The modifications Ethan Crumbley made to the original worksheet were significant. As for redactions, Ethan Crumbley scribbled out the gun, which closely resembled the Sig Sauer, the person bleeding from the bullet holes, and the phrases, "Help me," "My life is useless," "The world is dead," and "blood everywhere." Added to the worksheets were statements that "I love my life so much," "Harmless act," "We're all friends here," "OHS rocks," and "Video game this is." The modified worksheet provided a more complete picture of how Ethan Crumbley tried to cover up what he initially wrote and drew. And there you have it. Again, another example of the manipulations of Ethan Crumbley. Ethan Crumbley manipulated the adults around him, and that led them to believe and took advantage of the fact that they believed he was a good kid. When questioned by Hopkins, Ethan Crumbley said the video was of someone playing a video game, not an actual event, and that he enjoyed video games and was considering designing them as a career. Hopkins then asked Ethan Crumbley about the math worksheet, which Ethan Crumbley said was a drawing about a video game. After Hopkins asked Ethan Crumbley about the statement that "my life is useless," Ethan Crumbley's demeanor changed. According to Hopkins, Ethan Crumbley became sad and started discussing his various troubles in life, specifically mentioned his friend moving away, difficulty dealing with the restrictions put in place to address the COVID-19 pandemic, and his dog and grandparent dying. Ethan Crumbley also mentioned they argued with his parents the night before regarding his grades. Again, another fact that demonstrates that his parents cared about him. Why? Because they took the time to argue about his grades. If they didn't care about him, it would have been more expected that the reaction would have been they did nothing about his grades. That should have been the argument the state was making. Couldn't make that argument because guess what? They're doing everything you would expect a parent to do. They're arguing about grades. They're setting boundaries. They're setting consequences. They're doing the things that you would expect a parent to do with a child who is struggling to keep, to stay on track with school and things of that nature. Noting a concern about Ethan Crumbley's mental health and a particular suicidal ideation, Hopkins performed a risk assessment related to Ethan Crumbley. Hopkins then left a voicemail message for Jennifer and called James, who also did not answer. Jennifer eventually returned the call and was asked to come to the school to discuss Ethan Crumbley's situation. Hopkins forwarded Jennifer photographs of the math worksheet before and after modifications while they were speaking. Jennifer informed Hopkins that she would contact James to see who would come to school. In the meantime, Hopkins waited with Ethan Crumbley. Soon after the phone call, Jennifer attempted to contact James via Facebook Messenger, stating at 9:30 a.m., "Call now, emergency." In the following message, Jennifer attached both math sheet photographs. James responded at 9:44 a.m., "My God, what the fuck?" Immediately afterward, James informed Jennifer that the veterinarian still had not visited Pinnock's farm to see their ill horse. Jennifer stated she thought Ethan Crumbley was distraught about the night before and asked James to call her because she was driving to the school. Jennifer and James spoke on their cell phones for about 7 minutes before both arrived at the school, clearly again demonstrating they're believing that he is acting out, trying to get attention because he's upset because they've set restrictions on him based on the fact that his grade, I believe it was a trigonometry grade, was not where it was supposed to be. I believe it was a D or it was an F. When the defendants walked into Hopkins' office, they did not greet, touch, or hug Ethan Crumbley. I don't, I can tell you right now, when I walk into my kid's school, he's not going to want me hugging all over him in school at that point. So I don't think that's necessarily a problem, or any type of behavior that's out. Now, I probably would have made contact with him at the end of this, maybe put my arm around him and said, listen, buddy, I got you. But I'm not coming in hot, giving hugs and kisses and everything to my 14, 15-year-old son. I mean, I know that that's not a cool look for him. It's just not what he's going to want. Hopkins informed defendants about the video Ethan Crumbley had been watching during his first hour class. He had already sent Jennifer both versions of the math worksheet, told defendants he was concerned about Ethan Crumbley's mental health, provided them with mental health resources, and recommended they immediately take Ethan Crumbley to a doctor or therapist that day. Jennifer objected to that suggestion, opining that getting Ethan Crumbley care on that day was impossible because she and James had to return to work. I don't believe it was that. Of course, there's no audio recording. She probably said it's impossible because it is impossible to get your kid in unless you take him to the ER, as my wife will tell you. It's very difficult to get help same day unless you're taking him to the ER. So unless they were saying take him to the ER, which if they were, they wouldn't have let him return to class. I would bet that conversation did not have that. Now, I would bet that Hopkins and EJAC decided to say that she had to go back to work. I would bet that they definitely said that because they were, I'm sure, not wanting to take responsibility for the fact that Jennifer Crumbley, was pushing back on their assertion that he get counseling that day. And of course, they also knew they had egg on their face because they allowed him to go back to class and stay in the school. James did not disagree with Jennifer's statement. Despite his surprise at that decision, Hopkins insisted that Ethan Crumbley get medical attention within 48 hours because there was no disciplinary issue requiring Ethan to leave school. The decision was made for Ethan Crumbley to remain at school. Hopkins believed it was good that Ethan Crumbley would not be alone, considering the concerns about suicidal ideation. Of course, it's also left out in this discussion that Ethan Crumbley himself wanted to return to class and took extra special care to convince his parents of that. And it's also left out, or maybe we'll get into it here, about the fact that we learned in his trial that James Crumbley actually did walk him through that worksheet and question him and remind him that there was support available for him. During the nearly 15-minute meeting, Jennifer did not speak to Ethan Crumbley. James, on the other hand, expressed to Ethan Crumbley, that he had people with whom he could talk, including defendants, and encouraged Ethan Crumbley to write in his journal. Hopkins testified that Jennifer abruptly asked if the meeting was done, and Hopkins checked with EJAC before everyone left. On their way out, neither defendant hugged or said goodbye to Ethan Crumbley. Hopkins, though, told Ethan Crumbley, I just want you to know I care about you, because he did not believe Ethan Crumbley was getting parental support. Hopkins doubted whether defendants planned to get Ethan Crumbley help, so he planned to meet with Ethan Crumbley the next morning to see how he was doing. Neither EJAC, Hopkins, nor defendants asked to or looked inside Ethan Crumbley's backpack, which contained his journal and Sig Sawyer. This is what those two idiots were trying to cover up, because they had the book bag right there in the office and they let him walk back out. So did they take ordinary care? No, they didn't. Right? So they're going to try to paint the Crumbleys like they're these horrible parents when they're not. It's ridiculous. It's simply to cover his ass. Surveillance footage showed defendants leaving Oxford High School at 10:54 a.m. and driving out of the parking lot at 10:56 a.m. 2 minutes later, Jennifer contacted Pinnock to discuss a horse riding lesson scheduled for that evening. Jennifer told Pinnock about Ethan Crumbley's issues at school and forwarded photographs of both versions of Ethan Crumbley's math worksheet, but said she still planned to come to the lesson, though with Ethan Crumbley. Pinnock testified she was alarmed by the violent drawings and was aware that the Crumleys owned guns. Pinnock recommended equine therapy for Ethan Crumbley, to which Jennifer responded, "Yeah, well, he'll be coming out with me tonight. James is working. Ethan Crumbley can't be left alone." Pinnock asked if Ethan Crumbley would want to ride a horse, to which Jennifer wrote, "Maybe brush a small horse so he's not intimidated. Laugh out loud." While Jennifer messaged Pennock, James logged into DoorDash and accepted his first delivery job at 11 a.m., just 4 minutes after driving out of the school parking lot. Jennifer returned to work, where she spoke with coworkers about the school meeting. Jennifer reiterated her concerns about Ethan Crumbley being lonely given recent events in his life and showed both of them Ethan Crumbley's math worksheet. Jennifer said she felt like a failure as a parent, agreed with the assessment that the drawings were disturbing, and that Ethan Crumbley needed counseling, and reiterated that she felt like a failure as a parent. One coworker, however, also sensed that Jennifer was being sarcastic regarding the situation. At 12:21 p.m., Jennifer sent a text message to Ethan Crumbley asking if he was okay, and he responded he was and had just finished lunch. Jennifer then wrote, "You know you can talk to us and we won't judge." Sounds like a caring parent to me. To which Ethan Crumbley responded at 12:42, "Thank you. I'm sorry for that. I love you." Fewer than 10 minutes after sending that message, Ethan Crumbley went into a bathroom with his backpack, came out with a Sig Sauer, committed the unalivings while also injuring 6 other students and 1 teacher. By 12:58 p.m., the shooting was over. Oxford High School sent out alerts to parents about an active shooter within the school. Jennifer received the information while at work and started screaming. Upon receiving the alert, James drove home and unsuccessfully searched for the Sig Sauer ammunition. At 1:18 p.m., Jennifer responded to Ethan Crumbley's last text message by writing, "I love you too," and asking, "You okay?" 4 minutes later, Jennifer told Ethan Crumbley, "Don't do it." James apparently informed Jennifer of the missing gun and ammunition because she sent the following text message to a coworker at 1:23. "The gun is gone, and so are the bullets." Jennifer then called James, and while sounding frantic, said she was attempting to get to the school and expressed concern that Ethan Crumbley was going to commit suicide and that Ethan Crumbley must be the shooter. At 1:34 p.m., James Crumbley called 911 and told the operator his son went to Oxford High School and James' gun and ammunition were missing from his home. James relayed information about the school meeting and expressed concern that Ethan Crumbley took the gun and was the school shooter. Pennock testified that when she heard the news of the school shooting, she immediately thought Ethan Crumbley committed it, given the drawing on his math worksheet and the defendant's gun ownership. Poliquin came to a similar conclusion, adding that she was aware of Jennifer's Instagram post about purchasing a handgun for Ethan Crumbley. On the day of the shooting, police executed a search warrant for the defendant's home. In the defendant's bedroom, Adam Stoic found the gun case for the Sig Sauer open on the bed next to an empty box of 9mm ammunition in a locked gun safe in a dresser drawer of the defendant's bedroom. Sounds like it was stored in that box. The safe had a 3-digit combination lock, which was set at 00 and contained James' other 2 guns. All of the gun locks found in the house were still in their original packaging. Detective Stoic did not find any broken locks or a lock in which someone had tampered. Sergeant Matthew Pesky also participated in executing the search warrant and searched Ethan Crumbley's room. According to Sergeant Pesky, the paper targets from the gun range were tacked to the walls. Fired shell casings, an array of folding knives, a notebook containing detailed drawings of guns, and the feces of a small animal were on top of the nightstand. Trial court proceedings. Felony complaints against the defendants were issued soon after their arrest, both of which alleged that the defendants' grossly negligent conduct caused the deaths of the 4 victims by storing his or her ammunition and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent failure to perform the following legal duty, to wit: failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others, or from conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and opportunity to do so. After the conclusion of the 2-day preliminary hearing, the district court provided its decision to bind over the defendants as charged, citing People v. Head. The district court articulated its reasons for doing so. Therefore, in this case, after hearing extensive evidence, extensive testimony, as well as evidence and reviewing and viewing extensive exhibits, the court finds that the deaths of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in the care of their son. Specifically, the court finds that the prosecutor has shown by a probable cause standard that the defendant's son presented a danger to the community. Number 2, that danger was apparent to an ordinary mind. So I want you to understand, in order for him to be guilty of gross negligence, it had to have been apparent that he was a danger to the community. And the danger to the community would have been that he was going to commit a mass shooting. Karen McDonald argued to the jury that it was not about what was in their mind or what they knew. The court just said it was. Okay? Presented a danger to the community and said that the danger was apparent to an ordinary mind. And number 3, that the defendants, James and Jennifer Crumbley, neglected to diligently address and or divert that danger. And number 4, that the danger resulted in the 4 deaths of the young children at Oxford High School. In other words, that they neglected to diligently address and or divert that danger, right? So what is the danger? The danger here is that by mental defect, that he was struggling, and that as a result, they would have been aware of it, and they chose to do nothing. They chose to sit by and idly ignore the fact that he was exhibiting signs that he was going to go shoot up a school. Yet here they are worrying about grades. Here they are worrying about taking away his cell phone for grades. Here they are coming to the school, dealing with his disciplinary issues. Here they are telling him, write in a journal, talk to us. They're sending out supportive text messages. They're going to gun ranges with him to try to spend time with him, to try to connect with him. Yet we're to believe that they're also at the same time aware of mental health problems, aware that he is in this homicidal state of mind, and that they're just doing nothing about it. It makes no sense. That's a reasonable doubt right there. There was extensive testimony that Ethan Crumbley was certainly a troubled young man, and that the defendants had knowledge of that situation. But they purchased a gun, which he believed was his, and he was free to use. Therefore, the court is binding the defense over his charge. Now, obviously, some of those things are not as tight-knit and as straightforward as what they sound when they put it together. Also, of course, some of the evidence that was talked about only was going to be able to be presented in Jennifer's case, while it wasn't going to be admissible in James' case. Now they were going to try them together. This is why James and Jennifer separated their cases. It had nothing to do with blaming the other. Okay, it had to do with the fact that James did not want to have that other evidence in the ears and minds of the jury that's going to be considering his case. And thank God he didn't, because that's why that's why Karen McDonald was up there looking so uncomfortable, because she didn't have all of the BS that she had in the Jennifer Crumbley case to stand up there and say, see, look at these really bad parents. Before the circuit court, defendants filed a combined motion to quash the bind-over, contending that the district court abused its discretion by finding probable cause existed to believe the defendants committed involuntary manslaughter. In particular, defendants argued that the bind-over had to be quashed because, as a matter of law, the prosecution could not prove causation. So this is going to be the most important part right here, okay? And this is going to help you understand the manslaughter law and what you need to understand about it. Though acknowledging that the issue of proximate causation, as opposed to causation in fact, hinged on whether Ethan Crumbley's independent criminal actions were reasonably foreseeable, defendants argued that the district court's reliance on Head and its ultimate conclusion were in error. The circuit court issued an opinion in order denying the motion to quash, explaining why it could not accept the defendant's causation argument. The court concludes that sufficient evidence has been presented to allow a reasonable juror to find factual causation and to allow a reasonable juror to conclude that the deaths of the victims were a direct and natural result of the defendant's gross negligence. The court further concludes that the criminal misconduct of the defendant's son was an intervening cause but that a reasonable juror could conclude that his actions were reasonably foreseeable, thus negating the intervening clause. See, that's what I was talking about here. Therefore, the causal link between the defendant's actions and their liability for the deaths of the victims, as alleged by the people, is not severed by the actions of their son. A reasonable juror could conclude that the action of the defendant's son was a related link in the causal chain, but the only way that link stays intact is if it was reasonably foreseeable. And the only way the jury concludes it's reasonably foreseeable is if they think that they knew that their son was mentally challenged to the point, or mentally not challenged, but mentally deficient, that he was having problems and emotional issues to the point that he was a danger to the community and that he was a homicidal maniac, essentially, and they bought him a gun anyways. And there is no evidence of that. And yes, that does require them to believe that that's a possibility, that they knew that he was in that state. Because the circuit court concluded that the district court did not abuse its discretion in binding over the defendants as charged, it entered an order denying the motion to quash. So essentially, in a lot of times in pre-trial, or when it's before jury trial, they're going to look and say, well, they're not seeing the full body of evidence yet, and the state has the opportunity to try to prove their case beyond a reasonable doubt. So they're going to say that's an issue for the jury to determine. We're not going to involve ourselves at this moment. And once the case is said and done, they can do a review and say, well, wait a minute, was the theory argued to the jury, was the way they interpreted the law and the judge interpreted the law and presented the jury instructions and presented the law to the jury, was it fair, and did it meet the standards that it needed to meet? But anyways, so this is the standard of review. Basically, the issue at hand, as we established, is causation, is establishing whether or not it's okay for the reasonable foreseeableness of this crime happening, whether or not that overcomes and is truly enough to overcome the intentional acts of Ethan Crumbley. So here is the discussion of standard of review. This is analysis of the issues that they've identified. As with all issues we address on appeal, the first question we must answer, and often is one of the more critical ones, is what standard to apply when reviewing the court's decision. Appellate courts utilize varying standards of review, and which are employed depends on the issue raised, legal or factual, and the context in which it arose, from a trial, motion, ruling. De novo review involves no deference to the trial court decision and is usually limited to issues of law. On the other end of the spectrum is the abuse of discretion standard, which grants much deference to the trial court decision. Here, where we address a circuit court's decision on a motion to quash the binding decision made by the district court, there are multiple standards of review. In the context of reviewing a district court's bind-over decision, the order on appeal is the circuit court's decision denying the motion to quash, which we review de novo with no deference. In other words, they're not giving any benefit to the ruling court, because the dispositive question is whether the district court abused its discretion in binding over the defendants. Thus, although we give no deference to the circuit court's findings in its review of the district court's decision, we give a great deal of deference to the district court's decision. That is, we review that decision for an abuse of discretion. At its core, an abuse of discretion standard acknowledges that there will be circumstances in which there will be no single correct outcome. Rather, there will be more than one reasonable and principled outcome. An abuse of discretion occurs when a decision falls outside the range of reasonable and principled outcomes, and a trial court necessarily abuses its discretion when it makes an error of law. So they're saying the bind over in this case, the way they applied the law of reasonable foreseeableness, is an error. However, to the extent that a lower court's decision on a motion to quash the information is based on an interpretation of the law, appellate review of the interpretation is de novo, or interpretation of the law. It's regarding interpreting the law. Probable cause standards. In general terms, the purpose of a preliminary examination is to determine whether a crime was committed and whether there is probable cause to believe that the defendant committed it. More specifically, in order to bind a defendant over for trial in the circuit court, the district court must find probable cause that the defendant committed a felony based on there being evidence of each element of the crime charged or evidence from which the elements may be inferred. So they got to find that there's a probable cause that all elements of the crime are true, not beyond a reasonable doubt, but probable cause. Probable cause requires enough evidence to cause a person of ordinary caution and prudence to conscientiously entertain a reasonable belief of the defendant's guilt. The district court abuses its discretion by binding over a defendant when the prosecution has failed to present sufficient evidence to support each element of the charged offense. And in this case, they're talking about the reasonable foreseeableness, and or really not. They're talking about the causation factor by Ethan Crumbley intervening and committing with an intentional act that, in their opinion, means that element isn't met. With these standards in mind, we now turn to the narrow issue presented in this appeal: whether the district court abused its discretion in concluding that the prosecution presented sufficient evidence to establish probable cause to believe that defendants caused the deaths of the 4 unaliving victims. So here we go. We're having a discussion of causation. So listen closely, because this is the most important part that you're going to have here. Causation is, of course, an element of involuntary manslaughter. However, the concept of proximate causation is obscure. Drexler's Understanding Criminal Law, section 14.03. Nevertheless, in the criminal law context, the term cause has acquired a unique technical meaning. Specifically, the term and concept have 2 parts: factual causation and proximate causation. Factual causation exists if a finder of fact determines that. Now, this is a little footnote that we'll read here because I think it's important to understand this. Professor Drexler makes the point that despite such terms and phrasing such as superseding intervening cause, direct cause, and remote cause, there's no mechanical way to determine whether a defendant's action or interaction caused the victim's harm. In the process of determining proximate causation, courts and lawyers frequently bandy about conclusory terms like superseding intervening cause, direct cause, and remote cause. An observer might assume from this language that a formula exists to produce uniform and reliable results in proximate causation analysis. Although some scholars believe that causation is a metaphysical concept, it appears realistic to say that courts and juries don't discover the proximate cause of harm, they select it. The decision to attach causal responsibility for social harm to one rather than to another event is made in a hopefully common sense manner, or by application of moral intuitions, a community sense of justice, and or public policy considerations. Hence, why Carrie McDonald's arguing for them to use common sense. Anyways, so factual causation exists if a finder of fact determines that, but for the defendant's conduct, the result would not have occurred. The existence of factual causation alone, however, will not support the imposition of criminal liability. Meaning, in this case, it can't be that, well, if it wasn't for them buying the firearm, this wouldn't have happened. That's understood. It requires the existence of, you have to establish the proximate causation. In other words, you have to establish that they understood that there was a risk when they did that, and they did it anyways, even though they knew there was a high risk that somebody could get injured or be injured in a way that could result in death. And that's where we get to with this. That's why it's so dangerous the way Carrie McDonald was arguing things, and the way she presents it says it's the little things. It's the trigger lock. It's the stopping them from going into, taking them home. It's the not buying the ammunition. It's the locking up the gun and not just hiding it. It's the, what the problem is that those are all what we would call, those are all factual causation. That's and that is not enough on its side. You have to have factual causation, which is the how, or but for, which is something that happened, and say, well, this happens and it couldn't happen. And then you have to establish that it was the proximate cause. In other words, that they knew that when they did this, they had to have had a knowledge that what they were doing was dangerous, essentially. Proximate causation must also be established. People versus Schaefer. Concerns arise regarding whether the defendant's conduct was the proximate or legal cause of the decedent's death. when the death is so remote from the defendant's conduct that it would be unjust to permit conviction. In other words, proximate causation is a legal construct designed to prevent criminal liability from attaching when the result of the defendant's conduct is viewed as too remote or unnatural. Importantly, under criminal law, there can be more than one cause of harm, and a defendant's acts need only be a contributory cause that was a substantial factor in producing the harm. In assessing criminal liability for some harm, it is not necessary that the party convicted of a crime be the sole cause of the harm, only that he be a contributory cause that was a substantial factor in producing the harm. The criminal law does not require that there be but one proximate cause of harm found. Quite the contrary. All acts that proximately cause the harm are recognized by the law. For a defendant's conduct to be regarded as a proximate cause, the victim's injury must be a direct and natural result of the defendant's actions. Sometimes, as in this case, when there may be more than one potential cause of harm to the victim, it is necessary to examine whether there was an intervening cause that superseded the defendant's conduct such that the causal link between the defendant's conduct, i.e. buying the gun, i.e. not securing the gun, i.e. looking past that worksheet and not having taken Ethan Crumbley home from the school, it is necessary to examine whether there was an intervening cause, as we just went over all of those, that they would be that superseded the defendant's conduct such that the causal link between the defendant's conduct and the victim's injury was broken. If the finder of fact determines that an intervening cause supersedes a defendant's conduct such that the causal link between the defendant's conduct and the victim's injury was broken, proximate cause is lacking and criminal liability cannot be imposed. Feasel. Whether an intervening cause supersedes a defendant's conduct is a question of reasonable foreseeability. That was established in the Feasel case. Okay. So ordinary negligence is considered reasonably foreseeable, and it is thus not a superseding cause that would sever proximate causation. On the other hand, an act of God or the gross negligence or intentional misconduct by the victim or a third party will generally be considered a superseding cause. That's under Schaefer. So this is the issue here. Ordinary negligence is considered reasonably foreseeable, and it is thus not a superseding cause that would sever proximate causation. On the other hand, an act of God or the gross negligence or intentional misconduct by the victim or the third party is generally considered superseding. So Ethan Crumbley intentionally grabbing that gun, going into the school and committing an act under Schaefer should be enough to say, and this is why many other parents have never been charged. However, you're going to see what they do here. Nevertheless, the linchpin in the superseding cause analysis is whether the intervening cause was foreseeable based on an objective standard of reasonableness. If it was reasonably foreseeable, then the defendant's conduct will be considered a proximate cause. If, however, the intervening act by the victim or a third party was not reasonably foreseeable, e.g. gross negligence or intentional misconduct, then generally the causal link is severed and the defendant's conduct is not regarded as a proximate cause of the victim's injury or death. That line right there just contradicted what Kerry McDonald said, because the only reason why the state of Michigan was allowed to charge the Crumleys is if the Crumleys would have believed that the intentional act, which is the mass shooting, school shooting, that act had to have been reasonably foreseeable to them, meaning they had to have thought that he was going to do this and that it was a possibility that it could have happened. And that they believed that Ethan Crumbley, it was not that it was something, that was far off, that this was a reasonable thing that ordinary people faced with the same circumstances would have said, oh yeah, it appears I got a school shooter on my hand. Let me take the gun and ship it off to my dad's house, or let me just get rid of them altogether. That's what it means for reasonable foreseeable, for it to be reasonably foreseeable, and for it to then be determined as a proximate cause. That's why this was so important. That's why this created the door. It created the order of events that has to happen. You don't get to consider gross negligence in this case, or any of the theories of gross negligence, until you determine that the intentional act, the superseding act, this is why the attorneys, it frustrated me, they did not break this down to the jury, to put it in third grade language and say, listen, this has to be determined first. And then, and maybe the judge doesn't even understand this, or isn't willing to understand it. Then once we move past that, now we can say, okay, there wasn't a intervening or superseding cause that came into effect. Now, factual causation. 1, we quickly dispatch with any argument that factual causation did not exist. Factual causation is relatively easy to establish, as per People v. Rideout. The record squarely supports that but for the defendant's acts and omissions, Ethan Crumbley would not have killed the victims that day. In other words, they could have removed him from the school, killing never happens. Never bought him a gun, killing never happens. Locked that gun up in a safe. But, all these things could have happened. But just because those things were things that happened that they could have that could have affected the outcome, doesn't make any of them criminal in this case. Without them having to, without the intentional act Ethan Crumbley committed, being the school shooting, without it being considered reasonably foreseeable. On the basis of the evidence presented at the preliminary exam, a reasonable fact finder could conclude that Ethan Crumbley would not have been able to shoot and kill 4 students, but for the defendant's decision to purchase their mentally disturbed son a handgun. Their failure to properly secure the gun, and most importantly, their refusal to remove Ethan Crumbley from school when he made overt threats to hurt other people. But for defendants' informed decision to leave Ethan Crumbley at school, these murders would not have occurred. And okay, we'll accept that, right? Because, yes, had they taken him out, it would never been able to happen. Now, the proximate cause, most important discussion here. Listen to this. Take this in. Subsequent to the trial court denying the defense motion to quash, Ethan Crumbley pleaded guilty to 4 counts of first-degree premeditated unaliving. While there was no dispute during the trial, court proceedings that Ethan Crumbley's actions were intentional. His guilty pleas to first-degree premeditated unaliving cement that fact. Okay, so there it is. It's intentional. But was Ethan Crumbley's intentional misconduct an intervening cause that superseded the defendant's actions such that the causal link between the defendant's conduct and the victim's injury was broken, and proximate causes lacking and criminal liability cannot be imposed? Okay, again, an affirmative defense that they're allowed to bring before the jury, that it was not reasonably foreseeable. As a result, the intentional conduct superseded the conduct of not removing him from the school, maybe not securing the firearm, all of these things. Ethan Crumbley intentionally does this, and they could never have foreseen that. It's what was described in the Russ case. That's why I said he so very nicely describes that. He says, Alec Baldwin, nobody could foresee that he's going to go wild and start intentionally pulling the trigger on the set, except for the fact that this was an accident. And Baldwin doesn't admit that he did that. That's just what the state claims, or what the defense tried to bring up and say, well, it wasn't. But no, the state was saying it was an accident. Cross straw, boom. She didn't check the guns. I mean, there's not much of a case, there's not much of a defense there, unless you say there was intentional acts, and that they were claiming there was which is why they had the conspiracy theory, because an intentional act would completely say, if there was a conspiracy to set her up, then you could say, well, she couldn't have anticipated that conspiracy was going to happen. Although she could have checked the guns and followed protocols. That's why I see that case much different than I do this one. Defendants contend that the answer is yes, as they see firm statements in both Schaefer and Fiesel to the effect that the intervening gross negligence or intentional misconduct of a third party must always be a superseding cause. But as with many things in life, and this is where I talk about, this is where the due process issues come in. They literally redefined the manslaughter law in this case to justify these charges. This rule is not as black and white as the defendant suggests. Indeed, while the Schaeffer court may have used expansive language when discussing a specific example, it also made clear that the linchpin in the superseding cause analysis is whether the intervening cause was foreseeable based on an objective standard of reasonableness. Even when articulating the general rule that intentional misconduct on the part of a victim is considered sufficient to break the causal chain between the defendant and the victim, the court notes that this is so only because the intentional misconduct is not reasonably foreseeable. Feasel 486 Michigan 195. Hence, Ethan Crumbley's intentional misconduct did not, as a matter of law, supersede defendant's acts being a cause of the victim's death, as his acts will only supersede defendant's acts if its intentional acts were not reasonably foreseeable, which of course is generally the case. Okay, I want you to understand this line. Hence, they're finding that Ethan Crumbley's intentional misconduct did not, as a matter of law, supersede the defendant's acts being a cause of the victim's death, as his acts will only supersede the acts if his intentional acts were not reasonably foreseeable. So they're saying because they were reasonably foreseeable, they do not supersede his intentional acts, do not supersede the acts, the negligent acts of his parents. Okay? That's why the test here, the most important factor here is whether or not this crime was reasonably foreseeable. That's why the defense attorneys, all the attorneys in this case needed to have made this the most important thing for the jury to understand. Turning now to the district court's proximate cause determination. Now, I want you to look at what they're going to say are the facts, and I want you to contrast this with what Karen McDonald claims her burden was. The relevant facts reveal that prior to arriving at school on November 30th, 2021, the defendants were aware that Ethan Crumbley had been repeatedly experiencing significant episodes of hallucination and or extreme paranoia. That is knowledge. Ethan Crumbley was in a distressed mental state because of the loss of his grandparent and family dog and the departure of his best friend. Ethan Crumbley realized his poor mental state such that he requested the defendants to help him obtain medical assistance. Despite defendants' acknowledgement of Ethan Crumbley's mental state, they purchased him a handgun, which was readily accessible to Ethan Crumbley. On November 29th, the day before the shootings, Ethan Crumbley was researching bullets while in school. And during first hour of class on November 30th, Ethan Crumbley watched a video involving a shooting and during a second hour drew pictures of a bullet, a gun resembling the Sig Sauer, a person bleeding from bullet holes, and wrote blood everywhere. The thoughts won't stop. My life is useless, and the world is dead. Defendants were also presented with the significant modifications Ethan Crumbley made to that worksheet, where he clearly intended to portray a different, happier message about the school and himself. Despite their knowledge of all these circumstances, when given the option to help Ethan Crumbley and take him out of school, the defendants did nothing. That is not true. We've learned that that's not true. We've learned that they talked it over and talked it over with the counselors, and they agreed to get him help as per the treatment plan and action plan that was approved by the two school officials. They did not, contrary to the recommendations of Hopkins, take Ethan Crumbley home and get him immediate medical help, nor when they decided to leave him at school did they tell school officials about Ethan Crumbley's history of mental health issues, nor explain to them that Ethan Crumbley had access to a gun similar to the one he drew on the math worksheet. Defendants neither asked Ethan Crumbley if he had the gun with him, nor did they look in his backpack, and when they left the school, the defendants did not go home and ensure Ethan Crumbley had not taken the gun. Of course, these are all things that Ethan Crumbley's parents would have done if they really thought that their son was going to be a school shooter. But here's the thing. When you look at that case and you look at all the factors, it wasn't readily apparent. The messages they're talking about are 7 months old. James is trying to repair the relationship with his son and spend time with his son, hence why the firearms get introduced into their life. they're trying to actively deal with what they think is just a kid that's off track in school, that's not taking school serious, and they're just simply trying to get him to engage in school, get good grades, go on, and hopefully become a video game designer. That's what they think is going on. And there is nothing going on that would lead anyone, including his parents, to believe that we are on the path of a school shooting. And these four things are completely debunked. Defendants were aware Ethan Crumbley had been experiencing significant episodes of hallucinations and paranoia. That is no. He hadn't experienced any of that for 7 months, at least to their knowledge. And it was potentially just simply him trying to goof on his mom and make her believe that the poltergeist was back, because that was something that the family did. 2, Ethan Crumbley's in a distressed mental state because of the loss of his grandparent, family, dog, and departure of best friends. Yes, exactly. It's why his parents were going out of their way to spend extra time with him. That's why Jennifer Crumbley took him on a Mother's Sunday to the gun range, something she knew he enjoyed doing. Ethan Crumbley realized his personal poor mental state such that he requested defendants to help him obtain medical assistance. There was no evidence that that occurred because Ethan Crumbley didn't testify. And we don't know what he actually said or did. So that should have never been allowed in, and that, again, is something that will be up on appeal. But what we saw come in, no jury could conclude beyond a reasonable doubt, okay, that happened. So therefore, it doesn't rise to the level that it needs to. Despite the defendant's knowledge of Ethan Crumbley's mental state, they purchased him a handgun. What mental state? What was their knowledge 7 months before? They knew he was struggling or thinking that a poltergeist was in the house, something that was an ongoing joke. They've been spending time with him. James Crumbley's been bonding with him. What is the knowledge of the mental state? There is none. And on November 29th, the day before the shooting, she's researching bullets. Well, you see what his explanation is. You also see that the state accepted that he was a manipulator. He's manipulating his parents. And then, of course, watched the video, did the drawing, and we saw all of that. And we saw that Ethan Crumbley was in the room manipulating everyone in that room, making them believe it was nothing and trying to get his way back to class. So what knowledge did they have? They had no knowledge. They had the knowledge that their son was a 14-year-old kid, just being a 14-year-old kid, not taking school serious, not taking life serious, and clearly wanting to do other things than the things he was supposed to be responsible for. Despite their knowledge of all these circumstances, when given the option to help Ethan Crumbley and take him out of school, the defendants did nothing. They did not, contrary to recommendations of Hopkins, take him home and get him immediate help. Okay, I think I already read this. Given all these facts, it was not an abuse of discretion to conclude that there was probable cause to believe that a juror could conclude that a reasonably foreseeable outcome of defendant's alleged gross negligence was Ethan Crumbley committing a shooting that day. One of the few reasonably foreseeable outcomes of failing to secure the firearm that was gifted to Ethan Crumbley was that it would be accessible to Ethan Crumbley. Okay, and here it is, right here, guys. So they had that in his mentally deteriorated condition, he might use it in unlawful ways. Okay, this is the most important thing here that debunks what Karen McDonald was telling the jury. In his mentally deteriorated condition, he might use it in unlawful ways. So they would have had to believe that he was in a mentally deteriorated condition to such a degree that he would use the firearm in unlawful ways in order for them to find that this was reasonably foreseeable. That is the key and the gateway to that. So Karen McDonald says it's not about what they knew. Yes, it is. The Court of Appeals says that's exactly what they have to do. In light of those foreseeable events, when presented with what he had just drawn, written, and viewed that morning, a reasonable juror could conclude that it was foreseeable that Ethan Crumbley possessed his recently gifted gun and intended to use it that day. As a result, a reasonable juror could conclude that Ethan Crumbley's intervening acts were not a superseding cause of the murder. So what does this tell you? It tells you that the only consideration the jury has to make here, the main consideration that they have to make in order to be able to proceed with finding either of them guilty, is they have to find that it was reasonably foreseeable that these acts would have occurred, and then as a result, that will make the intentional act of Ethan Crumbley no longer a superseding cause of the unalivings. Okay, so without a doubt, right there, it lays it out. In fact, Given the uniqueness, and this is where I said they carve it out, given the uniqueness of the connection between Ethan Crumbley and the defendants, we question whether Ethan Crumbley's acts are properly considered as intervening causes capable of superseding the defendant's criminal responsibility. Indeed, in most cases involving a question of superseding cause, the third party or victim's act has no relation to the defendants. For example, in an early decision from the Supreme Court, People v. Rockwell, the defendant was convicted of manslaughter when he punched the decedent who fell to the ground. After he fell, a horse either jumped on or kicked the decedent, killing him. During a second trial, the jury queried whether the defendant could be guilty if he knocked the decedent down, but the horse killed him. The trial court instructed that he could, and the jury convicted. The Supreme Court reversed, holding that there was no connection between the defendant and the horse such that it was foreseeable that the death would occur. It is impossible to maintain such a charge without making everyone liable, not only for natural and probable consequences, but for all possible consequences and circumstances which immediately follow a wrongful act. There was no necessary connection between the act of the respondent and the conduct of the horse, which he cannot be said from the record to have been responsible for. So too in more recent proximate cause cases. In Schaefer, the alleged intervening cause was an allegedly negligently designed highway off-ramp, while in the companion case, People v. Large, the alleged intervening cause was the victim riding a bike in front of the defendant's car. The purported intervening cause in Fiesel was the victim's level of intoxication. In each of these decisions, there was no connection between the defendant and the intervening cause. They were separate and distinct from one another, which naturally led to the argument that the intervening cause was a superseding one. But here, as we've explained, the evidence shows the opposite. The defendant's actions and inactions were inexorably entwined with Ethan Crumbley's actions with the intervening cause. This connection exists not simply because of the parent-child relationship, but also because of the facts showing that the defendants were actively involved in Ethan Crumbley's mental state, remaining untreated, that they provided him with the weapon used to kill the victims, and that they refused to remove him from the situation that led directly to the shootings. In this circumstance, a reasonable juror could conclude that the defendant's conduct increased the foreseeable risk of a particular harm occurring through a second actor, State v. Pasquera, and that what Ethan Crumbley did at Oxford High School that day was foreseeable. Again, they are reiterating here that a reasonable juror could conclude that the conduct increased the foreseeable risk of particular harm occurring through a second actor. In other words, through their failure to act, that if they believed it was foreseeable, that because they were so close in proximity to Ethan Crumbley's mental health challenges, but here's the problem. That's not what the evidence showed. The evidence, in fact, showed that these parents had no idea. And that Ethan Crumbley, again, based on the theory based on what the state argued in his case, that he was a manipulator and that he was manipulating everyone to such a degree that it is not even worth having him reviewed for a potential parole hearing, as most minors and non-adult life sentences are reviewed under. They said, no, he's the most sinister, devious individual in the country to ever done something like this. He will fool the parole board. He's too dangerous. Well, if he's that dangerous, then could he be fooling his parents? Should we assume that just because they lived with each other, that they wouldn't be under the influence of Ethan Crumbley's manipulations to see things the way he wants them to see it? Finally, we share the defendant's concern about the potential for this decision to be applied in the future to parents whose situations vis-a-vis their child's intentional conduct is not as closely tied together, and or the warning signs and evidence were not as substantial as they are here. So again, remember, all of this ties into them having knowledge that he had a mental problem, and they believe the evidence was overwhelming based on what they saw without context and explanation. And in their opinion, or in the opinion of the appeals court, that would amount to things being foreseeable. The problem is when that isn't the case. When we look at what was actually presented at trial, and we realize There wasn't evidence to suggest that they really believed he was mentally defective. So how do we get there? Anyways, let's continue reading. But those concerns are significantly diminished by several well-established principles. First, the principle that gross negligent or intentional acts are generally superseding causes remains intact. See, this is where they carve out the standard and make it a separate deal that I believe won't survive or shouldn't survive a due process argument. We simply hold that with these unique facts and in this procedural posture and applicable standard overview, this case falls outside the general rule regarding intentional acts because Ethan Crumbley's acts were reasonably foreseeable, and that is the ultimate test that must be applied. I want to read that again. This case falls outside the general rule regarding intentional acts, okay, meaning normally the intentional act of Ethan Crumbley's would be considered a superseding cause, an intervening cause that supersedes the negligence. But in this case, because that's not the case, and the ultimate test in this case that has to be applied is whether or not it was reasonably foreseeable that Ethan Crumbley would do this. Second, our decision is based solely on the record evidence, and this is where they kind of give themselves an out here to say, well, we're basing it solely on the lower standard of evidence that's required, not the trial level of evidence that's required, not that it survives trial. Second, our decision is based solely on the record evidence and the actions and inactions taken by the defendants, despite the uniquely troubling facts of which they were fully aware. This point is important, as although the judiciary typically recognizes that the decision's precedent is limited by the facts at issue, it's particularly true when the court expresses that limitation. Third, our decision is premised upon a deferential standard of review and is based upon the record established at the preliminary exam. Whether a jury actually finds the causation has been proven after a full trial, where the record will almost surely be more expansive, including evidence produced by defendants, is an issue separate from what we would decide today. Now, here's a little accord here. We acknowledge that this was a little note. We acknowledge the defendant's argument that no parent could reasonably foresee their child committing a mass shooting, but these are issues based on the facts and what is reasonably foreseeable under an objective standard. And the circumstances defendants were presented with on November 30th, 2021, provided a heightened set of warnings that could lead a jury to find causation. Additionally, with respect to foreseeability, more relevant than the number of people shot is the foreseeability that Ethan Crumbley would shoot someone that day. Okay, so I want you to understand this is extremely important for a couple of reasons. This little carve out here. First of all, they acknowledge that the argument that no parent could reasonably foresee their child committing a mass shooting, they acknowledge that argument. But they're saying that based on the facts, what is reasonably foreseeable under objective standard, that the circumstances the defendants were presented with were such of extraordinary circumstances that it was a heightened set of warnings. Well, I think the defense has proven, based on the testimony of the two guys that were there wasn't a heightened set of warning. That these gentlemen, seeing everything but knowledge that the gun had been purchased 4 days before, they believed, again, while I said that was a question they should have asked, did you believe at that moment that this was the best outcome for Ethan Crumbley? And they obviously did. Ethan Crumbley obviously played a role in that, manipulating everyone in that room. But they provide us heightened set of warnings that could lead a jury to find causation. And additionally, with respect to foreseeability, it's about whether or not it was foreseeable that Ethan Crumbley would shoot someone that day. Meaning, it is about Karen McDonald is completely wrong. It is absolutely about what those parents thought, what was in their head. Did they believe that day he was going to do it? And they're saying a jury would have to find that by looking at that paper, that by looking at the set of circumstances, by looking at the full body of everything that had occurred in the previous 7 months, that they would have to absolutely say to themselves, yes, I think my son's about to commit a shooting, and I think I'm about to leave and go to work and do nothing to stop it. Even though they're telling him, you can talk to me, even though they're telling me, write in your journal, even though they're sending him supportive messages. It's ludicrous to believe that they're going to leave. And that's exactly what this court says they have to find in order to find them guilty. They have to find that it was foreseeable that he would shoot someone that day in order to proceed with the theory of gross negligence, whether it's a theory of duty of care or it's a theory of lack of securing the firearm. But they still have to survive that test. That is the ultimate test, as stated in this opinion. The district court did not abuse its discretion in determining Ethan Crumbley's decision to shoot 4 classmates. Was not a superseding cause because it was foreseeable based on an objective standard of reasonableness. Court's order, therefore, is affirmed. Okay, so there it is. They said they found that it was based on the body of evidence presented at the preliminary exam. They believe that that there was enough evidence to suggest by probable cause, by the standard of probable cause, that it's more likely than not that it was foreseeable and that the parents should have foresaw based on everything. Now we've gone to trial. Now we've heard the real truth. Now we've heard that it was not so cut and dry. Now we've heard and we've seen and we've identified and we've seen the things that were being done, and we've seen the fact that there's a 7-month gap between any knowledge that the parents had of any mental illness and the shooting. We know that steps were obviously taken, these steps being to bond with Ethan. That's why the guns come into play. And we have to, and regardless of what the state knows how ridiculous this assertion is, which is why they're standing up there saying, no, it's not that. It's not that. It's not that. It's not that. Don't believe it's that. Don't believe it's that. No, that's not what it is. That's not what it is. We don't have to find that. You just have to find that. Would a reasonable person think it's reasonable that they should have secured the gun, or that they should have left them, just taken them out of the school that day and not been so? But if they would have done that, they could have prevented this. As they tried to say, it's just the small little things. Well, it's the small little things. Those small little things do not matter, as per this decision, unless it passes the ultimate test. And the ultimate test is whether it was reasonably foreseeable that this would occur. And as per right here, the standard, with respect to foreseeability, more relevant than the number of people shot, which is what the state wants them to say. 4 people were shot that day. That's what matters, is the foreseeability that Ethan Crumbley would shoot someone that day, which the state has tried to shirk that burden and essentially did that. And that is why she was so uncomfortable, because she knew, as an officer of the court, she's required to make an honest argument. She's required to argue the law honestly. And when she's standing up there, knowing that the defense attorney doesn't have the opportunity to come up and clear up any misstatements or misapplications of the law, the only person in that room that can stop her is either the defense attorney objecting or the judge stepping in and saying, "Mr. Prosecutor, come on the sidebar. We can't have that. You're incorrectly stating the law." But short of that happening, she has an obligation to stand up before the court and hold out what the law is in an honest manner. She didn't do that. And it's sitting right there in front of you, right there. Additionally, with respect to foreseeability, more relevant than the number of people shot is the foreseeability that Ethan Crumbley would shoot someone that day, which is exactly what Karen McDonald claimed was not what they were supposed to be considering. This opinion just stated, the appeals court stated. Now, my deal is they acknowledge that they are carving out, that this is something they are carving out special, that this is a special circumstance. And they say that here when they're dealing with the concern of how this will be applied to other parental cases. And they basically say, this case is so extraordinary. It's so different than other cases. It rises to such a different level. It's its own deal. But the problem is, how was a Crumbley supposed to know what that level was? and what exactly is that level? Because they really don't get into it. They just say, well, it's just the facts of this case. So what you're saying is that every case, then, yes, correct. Karen's saying not to consider foreseeability meant it wasn't. Well, exactly. That's exactly correct. I mean, you could tell that was the whole point of what I was saying. Her demeanor, her body language, you could tell she knows this case is a turd, but she also knows the ramifications of losing this case and what it does to the Jennifer Crumbley case, right? She knows she's got a big problem on her hands. That's what she's scared of. I think she was looking at that jury, and I don't think she was getting the warm and fuzzies from the jury. They weren't vibing with her. They weren't connecting with her. They weren't going along with her. They were staring at her, and they were freaking her out. And she was freaking out. And she was getting lost in her arguments. She didn't know she was trying to make it sound and make it make sense. But this case doesn't make any sense against James Crumbley because you don't have the cheating. You don't have the people at work. You don't have the negative comments. What you have, because see, Jennifer was doing that to both her and her husband. I'm sure if people were talking, they'd say she talked about her husband like he was an idiot, which she clearly did. So she dogged both of them. But the thing was, James and Ethan were kind of tight. They probably bonded over the fact that she was a difficult person to be around. That was part of the bonding experience that they both had. And bottom line is, the bottom line is James Crumbley and Ethan Crumbley were close. James cared about his kid. James did not believe or did not foresee or had no reason to foresee based on what he had seen out of his son to think, hey, my son's about to commit a mass shooting. It makes no sense. And here it is. Let's go back here. I want to show the one thing here. And it's this line right here. Finally, we share the defendant's concern about the potential for this decision to be applied in the future to parents. But those concerns are significantly diminished by several well-established principles. First, the principle that grossly negligent or intentional acts or general superseding causes remains intact. We simply hold that with these, see, the way they get around it is, it's these unique facts, and in this procedural posture and applicable standard of review, this case falls outside the general rule regarding intentional acts because Ethan Crumbley's acts are reasonably foreseeable, and that is the ultimate test that must be applied. Second, our decision is based solely on a record of evidence and the actions or inactions taken by the defendants, despite the uniquely true. So what they're basically saying in code is they've decided that the facts of this case are so unique that it gets to go forward. And I guess what they're saying is, and this is an inappropriate application of the law, because the due process law, the 14th Amendment, requires that any law that's going to be enforced upon the citizens of this nation has to be able to be fully understood. And if you put 100 people in the room and you ask them, how do you violate this law? They should be able to tell you this. They should be able to tell you the exact same answer. If one or more or ever, or you get 50 different answers, then that law is not meeting the standard of the 14th Amendment required for general everyday citizens to understand how they can avoid breaking the law. It needs to be very clear. And everyone needs to be able to understand it. And if that isn't the case, and in this case, I think this meets it without a doubt, because nobody knows what that standard is. No one's going to know what the standard is until a crazy prosecutor charges them. Then it goes to a judge, then it goes up. That's not the way this works. That is against the due process clause of the Constitution, and it is against the fundamental way the justice system is supposed to work in the United States. And it violates U.S. due process clause in the Constitution, and it will. In every state constitution has a due process clause, so it's violating that as well. So on appeal, though, of course, obviously, no attorney wants it to get to appeal because it means their client got convicted. But on appeal, I'm sure that will be taken up because, as you saw, as we read at the beginning, this was a very limited scope, and the only thing they wanted considered here was whether or not the issue of whether or not the intentional act of of Ethan Crumbley should be considered a superseding cause, intervening superseding cause to this, and that the lower court abused their authority in finding that it wasn't. And that in the theory of the defense, that anytime there's an intentional act, they're saying that there was case law to support. At any time an intentional act occurs, you can never go forward. And that's pretty much what's been respected for years. Hence why you've never seen any other parents charged. And it was only Karen McDonald in her rogue prosecuting attorney's office who decided to go off the reservation here, charge the Crumbleys, because they figured, hey, these people bought their son a gun and they chose not to get into understanding things. And Jennifer Crumbley was a jerk, was not a likable person, pissed off the police, pissed off the prosecuting attorney's office, and they decided to go make an example of Jennifer Crumbley and Ethan Crumbley, or James Crumbley, and essentially try to send a message: think twice before you buy a gun for your kids, or with kids in the house, I guess. I mean, I guess that's what she said. It's not a gun. It's not a gun issue case. It is a gun issue case because you don't get around it. There's no way around that. It is. It's 100% an issue of gun rights. I mean, there's just no way around it. So, all right, let me jump back up here. Give me a moment here. We're gonna leave the document review room. Give me a moment here. All right, so went longer than what I thought, 2 hours and 37 minutes. I always tend to get caught up in here, but let's review. If you're just getting in here, you're catching up on this thing, you're going to want to go back and watch. We made a lot of progress here tonight, covering the James Crumbley case, going over what we think the verdict will be, contrasting the final arguments of Karen McDonald and Jennifer Crumbley's case with the final arguments of James Crumbley's case, and then taking it and reading it and comparing what Karen McDonald claimed was the burden of the state based on the case and the way they've, of course, tried to configure the jury instructions to match what the standard is in this case. The issue, as you probably have heard, in my opinion, is I don't think the defense attorney laid it out like they needed to in terms of making sure that they understood that the only issue in this case that is relevant is whether or not it was foreseeable. And I don't believe the state had that beyond a reasonable doubt in any way, shape, or form. As a result, that's an automatic not guilty. Nothing else matters. Securing the firearm doesn't matter. The duty to protect doesn't matter. None of that comes into effect unless the jury believes it was reasonably foreseeable. And then when you cross that threshold, it's a pretty easy verdict to get to. So we hope that jury's back there considering that they're not getting confused by the jury instructions. There's probably going to be some confusion. It'll be telling to see what questions come out of that jury. And then we'll see where we go with it. But I think that Jennifer Crumbley's jury struggled with this. They deliberated for, almost 3 days. And I wouldn't be surprised if you don't see some lengthy deliberations here as they're trying to work through this. But I don't think it'll be as long because I think Muriel Lehman did a good job. But I do think you're going to find some people that might come right out of the box and be partial or maybe believing certain things. And we hope the juror that is in that room, Ian has pointed out, has a prior manslaughter case. If that is true, we hope that juror steps up, can be a source and somebody who can help guide the deliberations and guide the way they apply and interpret the law in that jury room when they're deciding if James Crumbley is guilty or not. But I believe the correct verdict that we should see tomorrow, if a verdict comes down, will be not guilty. I believe that's going to be the outcome. For the facts I stated. But go back and watch this entire presentation. You will learn something. I guarantee it. You will, and let me know your thoughts. Let me know your thoughts. And obviously, we're going to be ending this here. I think it's not guilty, but the jury convicts, unfortunately. Well, I understand why you might think that, Ian, because of the way the outcome of Jennifer Crumbley's case happened. But I think that, look, I still think that, I think the way this case went, I think that jury is leaning when they left that courtroom, unless there's somebody on there that's just a strong personality that just takes this jury and flips it around. I really believe we're dealing with a jury that's favorable to the defense. And I think the defense did a good enough job. I think James Crumbley came across as a favorable individual, and I think it was helpful to have a sister in there because that added a little dose of humanity and was favorable to James Crumbley and the way that jury would feel about James Crumbley. So, but we'll see. We'll see. Of course, if a guilty verdict comes down, then we know, again, they gave in to emotion. Because the law, if this jury follows the law and applies the law, James Crumbley should be found not guilty. Bottom line, end of story. Put your vote in the comments of this video or put it in the chat. That's where I'm going to leave this at. I'll be up to start the stream, hopefully around 8:30, 9 o'clock to get the Verdict Watch stream, and I'll have it up. I'll be in and out doing things all day long, but we'll be keeping a close eye on the stream. As I mentioned, I'm not getting into any other cases right now just because of everything that's going on there that I've got to be involved with, especially once it hits Friday. It's going to be just full court press on getting ready for my father's memorial service. So I'll be kind of just letting it go, and then figuring out what the next trial will be, unless maybe we're still in deliberations come Monday. I mean, you never know. You never know. But we're definitely trying to start a new case on Monday. And go from there. So appreciate everybody watching tonight. Like I said, sorry it went so long, but that's how these things go. I mean, when you're going to read cases and you're going to dig in. Well, I think, Ian, that probably doesn't really have anything to do because I think that's just protocol. It's like I remember my dad being in the hospital once, and they came in at like 5 a.m. and had him put his lunch and dinner orders in, right? And then by 10 o'clock, his doctor comes in and says, "You're getting discharged after lunch." And I remember when I talked to him in that morning, he's like, "Oh yeah, I got my dinner order. I think I'll be in here tonight." And it turns out it didn't mean anything. It was just protocol. It was just the way they do it. And they would rather get the order in and have that taken care of just in case they're going to stay. Like I said, we could get back in, and it could be that they already came to a verdict. They got back there, didn't feel they needed to deliberate much. They took a vote, realized everybody's on the same page, and said, "You know what? Let's take an overnight and think about it, make sure everybody's comfortable with it, make sure no one needs to talk about anything else." And they come back, and by 10 o'clock tomorrow morning, there's a verdict. And then again, they could go the whole day, and, no verdict. We can have a hung jury. I mean, you just don't know. Juries are, but I think this jury, based on what I've seen, based on the way that final argument went, which we watched, I think they're leaning towards James Crumbley. That's my opinion. I could be wrong. I know there's a lot of people out there, but you have to remember the long crime polls, the fact that 24% watched that trial and think James Crumbley, that's actually really, really favorable because remember, everyone that's out here that's watching these things have all watched the Jennifer Crumbley case. So they're all biased. And there's a lot of evidence that came in the Jennifer Crumbley case that did make it into James, but they could absolutely taint your opinion of James. So if you're already believing she's guilty and you're inclined to believe guilt, then you're going to, probably be more apt to think that James is guilty. Yes, Ian. Well, yes. Have a good day, man. Have a good day. So, I guess you're right. I'm going to go ahead and get a little rest. I suppose you'll be in the middle of your day by the time we get the stream up and running. But have a good day. Have a good breakfast if you haven't eaten a breakfast yet. And like I said, I think that's where we're going to leave it. So I appreciate everybody that popped in here, everybody that said hello, everybody that's watching. Make your vote known. Put it in the comments. Guilty, not guilty, hung jury. And that's where we're going to leave it. So until then, guys, I'll talk to you soon.